progress.
Hope you are doing well. My watch says it's 10 o'clock, and we always start on time. Let me check with Teminkosi if we have a quorum. That's at least 16, not 16, it's a third. Do we have quorum, Honorable? Tembinkosi, good morning to you, and good morning to the support staff as well.
Good morning, Chairperson. Thank you. I'm glad that you corrected that 1/3. We do have the requisite number to start the meeting. I'm sure by the time I get off the call, probably would even have reached the quorum as members continue to join in. Thank you very much, Chair.
All right. Thank you very much, Teminkosi. Honorable members, so last week, I did not start the meeting correctly. So before we get into also my opening remarks, if I can ask that we observe a moment of silence for silent prayer and meditation so that we have a successful meeting of the Impeachment Committee. Can we take a moment for silent prayer and meditation? Thank you very much, honorable members. So today we continue with the ordinary meeting of the Impeachment Committee. I haven't even started the meeting. Honorable Mwitam, I saw your hand going up.
I'm sorry, Chair, I'm jumping the gun. I wanted to say something about the agenda, but I'll wait for you to say so.
All right. Thank you. I thought maybe the silent prayer and meditation was not enough, that you wanted to extend the moment for silent prayer and meditation, but thanks. Honorable members, so we continue with the work of the Impeachment Committee. And like I always say, that as a committee, we will focus on the work, focus on the things that are in our control, continue to do our work, and be guided by the rules of the National Assembly, guided by the Constitution of the Republic. So we are continuing with this meeting under those guidance. If I can ask Tembinkosi to please flag the agenda so that we can move to adopt the agenda of this meeting. Tembinkosi, please flag the agenda. Honorable members, this is the agenda for the meeting. We will have apologies, then we'll table correspondence. We'll get a briefing from CLSO on the court ruling. We'll then have a discussion on the evidence leader nominations, and then we'll consider the draft terms of reference, and then we'll adopt the minutes. So this is the agenda. Can I get the move of the agenda, or if someone believes that there's something that's on the agenda that shouldn't be on the agenda, can raise so. Honorable Ngola.
Thank you so much. Good morning to you and good morning to all the members. And apologies, Chair, I won't be able to switch on my video. The weather is terrible in the Eastern Cape. The bandwidth is too low. Chair, I see in the items that there is consideration and adoption of the terms of reference. If we recall, Chair, we would have taken a resolution which is also reflected in the minutes that we're supposed to adopt, that we would want to solicit a legal advice on a contentious issue in the terms of reference that relates to the legal compatibility of the president to testify before the committee. Will recall, Chair, there was an issue which was raised by Honorable Zungula of the terms of reference that say if the president elects. So I see, Chair, that there is an adoption part of that item, and the only legal advice that was circulated to members is that of the Western Cape High Court judgment. And we received nothing in respect of what is our approach in the consideration. So Chair, I wanted to check if the advice is available, and if not, can we not proceed with adoption? We can consider but not adopt if we have not yet got legal advice in that aspect. Thank you so much, Chair.
Thank you very much, Honorable Ngola. I do confirm that we still to receive that legal opinion, so we can amend the item to be the consideration of draft terms of reference, so that we get an update in terms of where we are, and we don't move towards adoption. Well, that I will say that that's in line with the resolution.
Thank you so much,
So
Chair.
we'll consider the terms of reference without adopting them. So we'll just amend that item to read that it's a consideration of draft terms of reference. Honorable Mngitama?
Thank you, Chair. Chair, this matter relates to our program of action moving forward. I want to put on the agenda already the need for the committee to consider an inspection in loco at Palapala itself, because that is the scene of the matter that we are dealing with here. So, Chair, I just want to put it on the agenda that we seriously consider that matter. And of course, it will have logistical implications, but that is the proposal that I'm putting forward as part of our preparatory work. Thank you, Chair.
Thank you. Can that matter be raised when we discuss the terms of reference? Honorable Ngitama, can you raise that matter when we get to that item?
Okay, Chair.
All right. Thanks. Honorable Direko, is your hand accidentally down, or you put it down yourself?
No, Chair. I think it's my network.
All right.
It's still
please,
up. Greetings, Chair, and greetings to honorable members. Chair, I will propose that we move the item of adoption of minutes upper, so that at least we can just refresh our mind in terms of the things that we have agreed on during the previous meeting. If it could be after the tabling of correspondence. Thank you, Chair.
Comrade Chair, sorry, I can't raise my hand on this device. Can you hear me?
I will note you. It's on it's on the agenda. The hands that I'm seeing, they are on the agenda. So there's a proposal to have the minutes after the tabling of correspondence. That's the proposal that we consider the minutes earlier. And I'll give a reflection on that. Honorable Dagmo, is it on the agenda?
Yes, thank you, Chair. I'd like to second the proposal that the minutes are moved up the agenda and are dealt with after correspondence. I think it's very important because the issues flowing out of the minutes which impact on the rest of the agenda. Thank you.
All right, thanks very much. Honorable Mahlaule, is that on the agenda, or you also agreeing on the adoption of or the minutes to be moved upper?
Thank you very much, Honorable Chairperson, and greetings to you and greetings to colleagues. I want to second that the adoption of minutes go upper, but differ that when we get to the consideration and of draft terms of reference, we discuss the inspection. It doesn't have space there. Rather, we speak about it when the Constitutional and Legal Services Office briefs us so that they tell us whether that is permissible to do in light of the judgment of the Western Cape High Court, rather than going to put it on the adoption of or consideration of draft terms of reference. Thank you.
Thank you very much. Honorable Sope, and then I'll close with Honorable Maneli.
Yes, good morning, honorable members. Thank you very much, Comrade Chair. Just two things that I wanted to raise. The issue of obtaining legal advice on whether or not the president should give evidence first. I don't have a problem with that. But it is not only Comrade Zungula who raised it. I was very vociferous in our meeting last time. I insisted that he must give evidence first. So it's true that Comrade Zungula raised it as well, but he's not the only one who raised it. I raised it at this platform. Secondly, this is a procedural point. When we talk about the appointment of the evidence leader, I'm also proposing at this stage that we should have more than just one evidence leader. This is a proposal, and I want us to deliberate on that. We should have two evidence leaders, the chief evidence leader and the assistant. And the idea is to ensure that we do not, as and when we start the work of the impeachment committee, we do not find ourselves being subjected to unnecessary postponements because the main evidence leader is not available. So the suggestion is that today, when we consider the appointment of the evidence leader, we should also have the assistant being considered and make those recommendations accordingly. I thank you, Chairperson. Thank you very much.
Thank you very much, Honorable Sope. Just to indicate that what we had agreed to in the meeting of the 24th of June was that we'll appoint the chief evidence leader, and the evidence leader will then recommend two assistant evidence leaders. So all in all, we'll have a team of three that will be leading the evidence. So we had agreed in terms of that process, and it's contained in the minutes. So what we consider is the chief evidence leader. Then once the chief evidence leader is appointed, then they will then recommend the two assistant evidence leaders. That's how we had resolved on that particular matter, and it's reflected on the minutes of the 24th of June. So that matter is already taken care of, Honorable Sope. Honorable Maneli?
Thank you.
No, thank you, Honorable Chairperson. Of course, I'm rising to firstly, second, or third the point about amending and putting minutes a little bit up to confirm our discussions that would have spoken to, but also agreeing that the point raised with regard to whether inspection log and that be dealt with at the time we look at the legal advice with regard to the outcomes of the court, so as to avoid a situation where probably that may be interpreted as actually dealing with evidence, which may be issues that involves even evidence leaders going forward. Thanks, Chair.
Thank you very much, honorable members. I am persuaded to say that we move the adoption of minutes earlier after the tabling of correspondence. We'll deal with the minutes, and that the matters relating to what Honorable Tama had raised, we deal with it when we get a briefing on the court ruling. So the amended agenda will then move to apologies. After apologies, we'll have tabling of contents. Tabling of correspondence. That will then be followed by adoption of minutes. We'll get a briefing from the CLSO on the High Court ruling. Then we'll consider the evidence leader nominations, and then consider the draft terms of reference. Then we close. Can I get a mover of the amended agenda?
I move, Chair.
Second. And seconded.
Honorable Nola moves, Honorable Dagmo seconds. So thanks very much. We now move to the second item, which is the apologies. Ngozi, did we receive any apologies? Honorable Dama is.
Yes, I want to indicate the apologies of Dr. Litchfield Shabalala.
All right. Thanks very much, Honorable Gama. That apology will be noted, and I take it that for the purposes of this meeting, you will then stand in as an alternate to Honorable Shabalala. So you will have your right to participate and speak in the meeting. I confirm that. Thembinkosi, can you confirm other apologies received?
Thank you, Chairperson. Morning once again to you and to the members and everyone on the platform. Only one apology, Chair, and that will be from Ms. Nesli Sharif of the Democratic Alliance, and the one that's already read, mentioned by Honorable Gama of Dr. Litchfield Chabalala. Thank you very much, Chair.
Thank you very much, Thembinkosi. One thing to check, honorable members, are there early departures from the meeting? Someone who's going to leave the meeting early so that we can note those as well. So there's no one that's going to leave the meeting early. So can we accept the apologies? Honorable Maimane?
Thank you, Chairperson, and let me apologize for not being able to switch on my video. What I will do is give notice to leave the meeting at 1, which is when it's scheduled to close. But if it does go on later than that, I have to submit an apology. I will not be able to stay beyond that point. So if it's not an apology, it's just to ask that as per the agenda directive to finish at 1. But if we can't, then I'll have to leave early. I apologize.
Thank you very much. Noted, Honorable Maimane. And if there's any member that after 1 o'clock, in case we are not finished, would like to leave the meeting, please do indicate either to myself on the chat or to Thembinkosi so that we note those departures. So thanks. We now move to the third item, which is the tabling of correspondence. Is it you, Thembinkosi, or it's Melissa that's tabling the correspondence received since the last meeting?
Thank you, Chair. Melissa will table the correspondence. Thank you, Chair.
All right. Melissa, could you please table the correspondence received since the last meeting?
Good morning, Chairperson, honorable members, support staff, and everyone in attendance. I will be sharing my screen shortly. Are you able to see my screen?
Yes, I can see your screen.
Okay. All right. So in the last meeting we had, parties were granted an opportunity to nominate additional evidence leaders. So that's basically what the correspondence consists of. Okay. So on the 22nd of July, the EFF nominated Advocate Thandazani Griffiths Madonsela as appointment as Chief Evidence Leader. The MK Party nominated Advocate Thandazani Griffiths Madonsela as well as Evidence Leader. The Freedom Front Plus nominated Advocate Yani Laba as Evidence Leader. The United Africans Transformations also nominated Advocate Thandazani Griffiths Madonsela. And then the Inkatha Freedom Party nominated Advocate Ceci Baloyi and Advocate Carol Steinberg for appointment as Chief Evidence Leaders. The African Transformation Movement nominated Advocate Tani Siboko for appointment as evidence leader. And those are the only additional nominations, Chairperson. Thank you.
Thank you very much, Melissa. So that's the correspondence that the office has received since our last meeting. Can we please note the correspondence received? These correspondence were acknowledged, and those that have submitted nominations were informed that we acknowledge, and hence you have seen the list being circulated. So thank you very much, Melissa, and thanks, honorable members. We'll now move to the minutes. Temgosi, if you could just take us through the minutes, especially on the resolutions, but you can start on top in case someone needs to raise any issue. But the important aspect is to go to the resolutions of the meeting, because that's the issue there, and there's a resolution that legal will also reflect on.
Thank you very much, Chairperson. And honorable members, those are the minutes of the 22nd of July, 2026. That would have been last week on Wednesday. And those were the 4 agenda items: correspondence, consideration of draft terms of reference, consideration of recommended evidence leader, and consideration and adoption of minutes. And those were the first few pages relate to the attendance. The minutes were shared with the members. If there's a name that is missing, members can indicate so that we can correct. The welcoming, which was done by the chairperson, the apologies by the secretary, same as the tabling of correspondence. And then it was the discussion on the recommended evidence leaders, discussions on submitted inputs on the terms of reference, a document that was tabled by Advocate Nell. And then, Chair, it was the resolutions following the deliberations of the committee. As Melissa had indicated in the tabling of correspondence, political parties were granted an extension of 48 hours, which was until Friday, 1800 on Friday, to submit additional nominees for appointment as evidence leader. And Parliamentary Legal Services would then conduct the necessary due diligence on all nominees and submit the final list to the committee on Monday, 27th July 2026. The second one, Chair, also was an extension that was granted, same until 1800 on Friday, on the terms of reference for members to make submissions and also lobby each other so that they may hold a view to reach a consensus and to submit their additional input on this matter, like I've indicated, at 6 o'clock on last Friday. And then, Chairperson, there was Resolution C, where in the committee, in consultation with Parliamentary Legal Services, will write to the authors of the independent panel report to check whether they would avail themselves of appearing before the committee and presenting the report should the need arise. And also Parliamentary Legal Services were requested to provide an opinion on the following questions: whether the president can be compelled to give evidence to the committee, whether a negative inference can be made if the president refuses to give evidence to the committee, and what would the recommended sequence of proceedings and presentation of evidence be for an inquiry of this nature. I think, Chair, you'd also want to invite legal services to speak to the issues that have just to the Resolution C and Resolution D. And Chair, then it was the tabling of the minutes of 24th of June, which were adopted, and the closure of the meeting. I therefore table the minutes. Thank you very much, Person.
Thank you very much, Temgosi. So legal will come in on Resolution C and D. But before I invite legal, I would like to get a mover of the minutes as a true reflection of the meeting that we had last week, Wednesday. Honorable Mpapane.
Thank you, Honorable Chairperson. Good morning to you and my colleagues on the platform. I move for the adoption of the minutes as a true reflection of what we discussed. Thank you.
All right. Honorable Dagmar.
Thanks, Chair. I would just like to second the adoption of the minutes as moved by Honourable Mbapane.
Thank you very much. Honourable members, as you saw in the minutes, there are two resolutions. The other one was in terms of the independent panel that we had a resolution. If you can fly that, Temikosi Resolution C, that we consult with the legal services. We did consult, and I'll allow the legal services to just give the opinion insofar as the independent panel report is concerned, but also give a status update insofar as Resolution D of our last meeting. Is that you, Mr. Prince, that's giving just...
Good morning, Chair. That is correct. Good morning,
on the
members.
two matters. Can you start with the one in terms of the
Chair, as far as... am I audible?
I can hear you loud and clear, and I can see you as well.
Good morning, Chair, and good morning, members. Chair, as far as Resolution C is concerned, maybe I should start with Resolution D. Chair, we are in the process of finalising the opinion pertaining to the request for legal advice contained in Resolution D. We have received updated research from the research unit this week, so we would wish to include that in our opinion. As far as Resolution C is concerned, Chair, just to say that our views pertaining to Resolution C will also be included in the opinion for the members to reflect on. But if I can move on to our views as far as Resolution C is concerned. Chair, we are of the view that the independent panel has discharged its statutory functions upon submission of its report on the 30th of November 2022. The National Assembly rules confer no further role on the panel once the report has been referred onward. In law, our view is that the panel is as functus official. Rule 129G confines the panel to a sifting function, expressly precluding an oral hearing. Rule 129M, by contrast, assigns the substantive fact-finding function, in other words, testing evidence and establishing the veracity and, in some cases, the seriousness of the charges to the Impeachment Committee. These two functions are structurally distinct and were not intended to overlap. A request for the panel to brief the Impeachment Committee on its report would require the panel to explain and in substance, elaborate upon its findings. This risks overlapping, or collapsing rather, the separation between the panel's preliminary sifting role and the committee's independent fact-finding role. This concern is reinforced by the panel's conduct in the President's pending review of their report. The panel members were cited as parties to that review, but elected to abide the outcome, taking no active position in defense of the report. A briefing to the committee, we believe, at this stage would be inconsistent with that posture. By way of analogy, the position would be comparable to an appellate court hearing an appeal against an order made by a court quo, inviting the judges of the court quo to brief the appellate court on the reasoning underlying their own order. Such a course would not ordinarily be countenanced, since the judgment must be capable of speaking and being tested on its own accord, independently of any further explanation supplied by the judges who made it. The same principle we submit applies to the panel's report. The panel's report must stand or fall on its own written record and should not be supplemented by a further account from its authors. In addition to the structural objection set out above what I've just explained, the Impeachment Committee is presently interdicted from proceeding with the hearing of the evidence pending determination of the President's review. A substantive briefing from the panel would likely fall within the scope of that restraint. Chairperson, it is for these reasons that we do not recommend that the committee request a briefing from the independent panel on the content or reasoning of its report. Thank you, Chairperson.
Thank you very much, Mr. Prince. So, honorable members, that's the advice from the legal services as it relates to ourselves inviting the independent panel to come and brief the committee. There might be desires to reflect on that, but I will ask Mr. Prince through Temikosi that we also get that opinion circulated to members also for their own records, so that we have it on record. I have the hand of Honorable Swart, that will be followed by Honorable Mutambi and Honorable Dagmo.
Thank you, Chairman, and good morning to you and to the colleagues. And thanks once again for opening in prayer. Much appreciated. And meditation. Chair, I don't want to disagree with the legal opinion that is being granted. It would be helpful to read it. But my question then arises, given the fact that the panel's report is the whole origin, almost. You start with the motion and then you go to the report. Who will then present the report to us as the committee? Will it be the evidence leader, or is it just, it's tabled before us? Do we then of our own go through it? That could possibly come into the terms of reference. How do we deal with the terms of reference with the panel's report? I think we just need, we might need some deliberation on that then. How is it dealt with? One would probably think the evidence leader would then go through that in conjunction with the committee. So that I'd need some clarity. But I want to appreciate the opinion, and I look forward to obtaining it. Thank you.
Thank you very much, Honorable Mutambi.
Thank you, Chairperson, for the opportunity, and greetings to all the colleagues in the platform. I'm partially covered by what Honorable Swart has just said, but also we have agreed as a principal matter to say this matter, we knew it was going to arise. It will have been very prudent for the team to have sent us this opinion based on our resolution as a matter arising. So can we then, to support Honorable Swart, let's get that opinion, and you had already made the ruling, Chairperson, to that effect. Secondly, it's with regard to 6D. With regard to the legal opinion that relates to 6D, Chair, because it also impacts on the agenda item that we're going to consider, because that is part of the terms of reference. The intention that we said we must get legal clarity was for us to also deal with that item when we come to the terms of reference. So both two now, it impacts on how do we finalize the terms of reference, and without them, I think it's going to make our life very difficult to say, how do we process that? Because it's of concern to say then, if we are going to deal with the report itself, and then there's no clarity whether the authors of the report are going to come and talk to their report. And then also, so it's a matter of concern also to say, does it mean that we're only solely going to rely on the report as the gospel truth? So these are some of the concerns that we are having, Chair. So that's why it's very important that we get the two legal opinions and we're given an opportunity to reflect on them. Thank you, Chair, for the opportunity.
Thank you very much, Honorable Mutambi. Honorable Dagmo.
Thanks very much, Chair. Chair, I'd like to welcome the report. I know that we are going to get an opinion, after we've dealt with this matter, but I think we really need to, as a committee, accept the fact that in terms of the ruling, which is what was referred to in this opinion, the review application places into question the issue of the panel's report. And until that review application is heard, there would be no sense to call the members of the panel. And I think we should accept that, but I'm sure we will discuss it more when we deal with the opinion. Secondly, we had resolved, as the minutes reflect, that we needed the opinion regarding issues related to the appearance of the president. We've now heard that the legal team of Parliament is still busy with that. Could we get an indication as to when? Because I agree with Honourable Mutambi, and Swart, it's very difficult to deal with these matters, unless we actually have an opinion to engage on. So what I would like to ask is, Chairperson, is by when will the opinion that the minutes reflected we should get be provided to the committee? Thank you, Chair.
Thank you, Honorable Dagmo. Honorable Mautwe.
Thank you very much, Chair. Greetings to yourself, your team, the back office, and to the honorable members and everyone who's on the platform today. Chair, I don't know why we want to go around in circles. We've got the rules of parliament that clearly stipulates the process of impeachment. A motion was tabled to the speaker. The speaker then took the motion to establish the independent panel report, a committee which produced the report. The independent panel, its main duty or its purpose was to establish if there is a prima facie, and it has done exactly that. They've concluded what they needed to do, which is their mandate. The mandate of this committee is now to establish the veracity of the allegations. And we do that by calling witnesses and assessing the evidence that they will put before us. So there's no point of calling the independent panel to come back to present to us. That's how law works. If you send your issue to court, it gets read through the papers. Your legal team goes and represent you, and the judges make a ruling. Once the ruling is made, it's done. If you want to take the ruling on review, the next court is not going to call for the judges who made that ruling. They read what that ruling is saying. That's basically what we're supposed to be doing. The evidence leader is going to then take this report and share it with us and present it to us and tell us this is what the independent panel has found. And this is now what we now need to do to establish the veracity of these allegations. So there's no point at all in us trying to, but also it's not even provided for in the rules. So there's no need for the independent panel to come and present to us. They've done their job. Now we have the job ahead of us to take this matter forward. I thank you, Chair.
Thank you very much, Honorable Mautwe. Honorable Zungula. Then I'll go to Honorable Gama, Daniels, and Mahlaule, and then we'll just move on this matter. Thank you very much, Honorable Zungula.
Sorry,
Thank you.
Chair, I would also want to say something. I can't raise my hand.
All right, I'll note you,
No,
Honorable
I can be
Fake.
the last one. I'll be the last one, no problem. Thank you.
Honorable Zungula.
Thank you, Chair. Greetings to you, the colleagues, the staff of Parliament, and everyone that has joined in the platform. I think, Chair, if we were to look at the precedents that was sent, that was made in the Mkhwebane impeachment process, there was a similar process in that there was first a panel report that was done. I think it was chaired by Judge Ngabinde. However, there was no requirement for Judge Ngabinde to actually go and table the report to that Section 194 process. So learning from that process, I think we can then agree with the sentiments that have been shared by the colleagues here that there's no need for the independent panel to come. The evidence leaders would then take ownership of the independent panel report, be the ones to table the report to the committee. The last thing, Chair, I want to speak to is that the independent panel report is valid. The fact that there is a review, that does not question the validity of the report. The report, in accordance to even the Constitutional Court judgment, is that it is valid up until set aside. So I think let's move from the premise that that report is valid. The only time we can question the validity of the report, it is only when there's a court order that has made that particular pronouncement, and it is a final pronouncement. Between now and then, we must not second guess a report that was made through the processes of Parliament, and there is no Parliament authority that has questioned the validity of that report. So other people outside of Parliament can have their opinion on the validity of the report, but the members of Parliament who have mechanisms inside Parliament, if there is any report that is not valid, to question it, and they've not done so. So we must shy away, Chair, from creating an impression that even the committee itself is second-guessing the validity of the report. Thank you.
Thank you, Honorable Zungula. Honorable Gama.
Thank you, Chair.
If you can mute yourself, Honorable Shope, it will assist. Or Tembingos, if you could just please, all right, continue, Honorable Gama.
Okay, I hope you can hear me, Chair.
I can hear you loud and clear.
Wonderful. Chair, in my view, the panel report is the property of Parliament, and it constitutes the official evidence and foundational property of the committee, of this committee. So it seems to me that we are trying to orphan the report, and yet the report, in fact, as the Constitutional Court said, they ordered that the Section 89 report be tabled before the impeachment committee. So the report legally resides with the impeachment committee. That's my view. Thank you.
Thank you very much, Honorable Daniels.
Good morning, Chairperson. Good morning, colleagues. I trust I'm audible enough, Chairperson.
Very, very audible.
Thank you very much. Yeah, no, Chairperson, I note the comments made on the panel's report. There's no issue with that. It is just that I don't want us to be found not focusing on the review, the pending date that is still need to take place, Chairperson, because whatever we do, when the report comes, and you as the Chairperson must be very cognizant that this impeachment committee, we didn't lose our institutional existence, but its operative adjudicative function has been suspended. Something similar to seeing it as if our hearing machinery is now frozen, Chairperson. And when it comes to this report, the timing of that and how we are going to manage that is important, purely because of the order which has been granted in terms of the interdict. So whatever we do, let us just be cognizant, Chairperson, on that particular item of how we go about. Thank you.
Thank you very much, Honorable Mahlaul, and then we'll conclude with Honorable Shope.
Thank you very much, Chair. I do think that the authors of the report ought to come and present it to the committee at an appropriate point. As it is now, the president has taken it for review, meaning there are questionable things that are there. Because this can't be a one-way street. The president ought to find fairness in the entire process. What if we want to ask some questions about the report, how it became, what steps have been followed to reach the determination that they have received? I don't think there is a evidence leader who will take authority to respond to us in that manner. So it becomes important that we do have the authors of the report coming to present to us. Secondly, Chair, amplifying what Honorable Mutambi was saying, the legal opinion on whether the president can be compelled to give evidence in person or otherwise has been a central point of discussion. You heard Honorable Hlope saying it has not only been raised by Honorable Zungula, he raised it. Now, if that is going to be the central point of what we're going to discuss when we get to the terms of reference, why do we then want to proceed without that legal opinion? Because that legal opinion will guide us into agreeing or disagreeing when we get there. So I'm not sure whether the absence of that legal opinion will allow us to proceed to discuss the terms of reference at the time we get to that agenda item, Chairperson. Thank you.
Thank you. Honorable Hlope.
Thank you very much, Chairperson. Am I audible?
We can hear you loud and clear.
Thank you. Thank you, Chairperson, for the opportunity. I'm going to be brief. Where I come from, the report is before us. It would be wrong to call the authors of the report to come and give evidence regarding the report that has already been tabled and that has already served before the Constitutional Court when it reserved judgment. I have made this point before. This report sat before judges of the Constitutional Court. There is no way those judges would have come to the conclusion that the matter must be interrogated further if the report was nonsensical or defective. Prima facie, the report has merit, and it is very clear from the report that it's based on the evidence that President Ramaphosa had given his own version. It's going to be humiliating. We're dealing with judges here. Why, if they refuse to come here? Then it's going to be a long drawn process. I can assure you, knowing Chief Justice Ngobo, he will never subject himself to this. He has spoken, and please let us just move on. The report, I agree with the view of Honorable Swart that the report must be presented to us by the evidence leader. We've got to work with what we have. We can't second guess it. It can be interrogated. It speaks for itself. Thank you very much, Chairperson. I submit.
So I had said that Honorable Hlope is the last one. I see the hand of Honorable Ngola and Honorable Dagmo. Is it a new point on this? So we need to move on this. Is it a new point on
Yes,
the legal
Chair,
opinion?
on the same matter, Chair, just a smaller issue which I think all members are missing on what is being proposed in respect of the independent Section 9 panel. Members will recall that this is not about second guessing the report, but this is about officializing the report. Remember, Chair, in the past, the panel officially handed over the report to the presiding officers because the rules directed that from the Section 89 independent panel to the National Assembly. Then the National Assembly decides whether it goes to the impeachment committee or not. So the Constitutional Court changed that systematic process and said, from the Section 89 independent panel to the impeachment committee, then to the National Assembly. So the process has been reinvented. So if the report was handed properly so to the presiding officers, because the rules which were declared unconstitutional by the Constitutional Court was officially handed over to the presiding officers because the rules directed so. Now it has been changed owing to the Constitutional Court judgment. Now, it means then, therefore, we need to have our own as the impeachment committee, because the process has been reinvented. Who are the secondary recipients or the primary recipients of the report in terms of the Constitutional Court judgment? Now, that's how it becomes incumbent that they come and officially hand over officially table the report before the impeachment committee. So that's from what I'm reading from what is being proposed, but not to particular on gas and stuff. Thank you, Chair.
All right, thanks very much. Honorable Mauta, I want to recognize you. Let me just move towards a ruling. Just to say, on the last point that you raised, Honorable Nola, the report has been, when the Constitutional Court made the ruling, the report was referred to the committee, and the Speaker did refer the report to the committee. It was 80 seats referred. It's now with the committee. The report itself, it has been handed over to ourselves. So there are two views. One is that, as articulated by the legal, that we don't, in fact, we must not call the independent panel, the authors of the report, to come to the committee. Their work is done, so that a report will then be presented by the evidence leaders. That's one view, which I've had enough people supporting the view that the authors of the report, as it happened in the section 194, the Inquiry, that the authors of the panel report did not appear before the committee to table the report. It was referred to the committee by the Speaker. And if we were to take it, we take the report as is, and then the evidence leaders that we are going to appoint will then take us through that report. The other view, which runs contrary to what the legal says, is that the authors must come to the committee. So these are the two views that are emerging. Generally, I try to move towards a consensus, but in the absence of a consensus, I will ask people to vote. I want to check, because if we take precedence, especially the point that you have argued, Honorable Mataule, from the section 194, wherein the authors of the panel report did not present their report to the committee and be questioned in terms of what their findings are, which is the view that's supported by legal. Are you persuaded that we move with the legal advice, that we don't call the authors, but the evidence leaders take us through the report, which will then be used as a basis to identify the legal, the witnesses that will need to come and appear before the committee? If you are not persuaded, then we are going to a vote so that we move on this particular matter. Are you persuaded, Honorable Mahlaule, or you wanted
Chairperson,
to go to a vote?
Chairperson.
Honorable Mahlaule?
Thank you very much. Not to be unreasonable, Chairperson, may I propose that we don't take a final decision now? We look at that judgment, that legal advice that was given, and we sought our own legal advice on that legal advice, and then we can take a final decision there. It will be unreasonable to vote for something that we found it now. We are trying to comprehend, and we are not really disagreeing with it because we are unreasonable. We want to be reasonable, even if you can defer it, and then we look at it and we come back with it, with the answer. That's my proposal. I don't know how we want to move, Chair. Thanks.
Thanks, Honorable Mahlaule.
Second that proposal. Can you put that proposal
But
to the vote?
Chair, you are being unfair to me. My hand was up. You refused to take it. Honorable Mahlaule come in and speaks, and you don't stop him. And even Honorable Dagmo just comes in and speaks. You recognize them, but my hand is up. You refuse to take it.
But he just did what Honorable Dagmo did.
You're unfair to me, Chair, please.
No, I was coming. So I wanted to first, Honorable Mauto, to get Matlaule to see, because he had made the proposal to that the panel comes, and I was trying to check whether he has been persuaded, because he's not. My view is that the prevailing opinion of the meeting is that the independent panel report, or the authors of the independent panel report don't have to come to the committee. But if Honorable Matlaule, as seconded by Honorable Dagmo, would like to take a view on the legal opinion from legal services that will be circulated, that's in order. I see the hands. I see all your hands, members. I am of the view that we don't need or not that we don't need. The independent panel has concluded its work as advised by the legal services, that they don't have to come and present to the committee. Are these hands contrary to the view, or they are supporting the view that I just said? Honorable Mautwe, I see so many hands, and then
Yes.
Because there are so many hands, let me just take this matter to a vote, and then I'll allow honorable members, if they want to challenge that ruling, or they will seek a legal opinion after that.
Order point. I've got a point of order, Chair.
What is your point of order, Honorable Dagmo?
The point of order is, Chair, in terms of meeting procedure, there was a proposal by Honorable Mhlawuli, seconded by myself. So that is a second motion that has been seconded. So that motion says, let us delay a decision on this until we get the formal report and we discuss again. So you can't just call a vote on your motion. There's another motion you have to entertain now.
All right. I will subject all the motions to a vote, Honorable Dagmo. Let me recognize Honorable Maute.
Thank you,
and then
Chair.
I'll recognize all the hands that have been raised. If they want to add to this, then I'll put all the matters to the decision of the committee. Honorable Maute.
Thank you, Chair. Chair, we must always refer to the rules. There's no rule that says that the independent panel authors must come and present to us. The independent panel is done. They've done their job. The report is now a product of Parliament. It's a property of Parliament. And that property of Parliament was referred to the Constitutional Court. And the Constitutional Court said that property of Parliament must be subjected to this, must be a subject of this process of the impeachment committee until such time that is set aside by a court of law. The independent panel report has not been set aside. So it is the law, it is the Bible of this committee until such time that it is set aside by the law. There is no need. That's why even the judges that authored that document said we're not going to participate in court to defend our own thing because it's no longer our product. It's a product of Parliament. So why are we saying we need the authors to come? And we are the authors now because we are the ones who voted in that National Assembly. Oh, by the way, most of you voted against it, but the EFF and ATM took the matter to the Concord. And the Concord said, all of you who voted against it, you are wrong. And therefore, we are here now. So now we are here. The report is our report. Why do we need anybody else to come and present to us? It's us. 1. 2, there's no provision in the rules of Parliament for such. 3, the report has not been set aside by any court of law. And therefore, Chair, we should follow what the Constitutional Court said, that we should, with immediate effect, without any further delays, subject that thing to the impeachment committee, which is where we are now. And Chair, we are with you to say there is no need. Let's proceed with the work of Parliament of the impeachment of the president of the country. Thank you, Chair.
Honorable Ngobeni.
Thank you, Chairperson. I actually wasn't going to take a bite, but I've been listening to all of the deliberations, and I feel like we're really going around in circles. I don't think that the authors of the independent report really should be on trial to defend that report. We should proceed with our prep work as we had asserted that even after the interim judgment has been set, we are going to continue with our prep work, which is what we should be doing in this particular meeting. And so I want to stand with the assertion that we proceed with what we have on the table. We do not need, I don't think that we can process it, what Honorable Masaule is proposing for us to be put it to a vote. I think we should just do that and proceed with this work because it seems now like we're going around in circles. My assertion here is to say, let's proceed with the legal opinion as has been presented, but also to say we're not a trial within a trial now of the authors of the independent report. What we are doing is to prepare ourselves to test the veracity, like I think a previous honorable member did state. And so I would support the assertion that we proceed in this regard. But if there is an issue, let's not go around in circles. If we must put Honorable Masaule's point to a vote, let's do that so we can proceed with this meeting. Thanks very much.
Thank you. Honorable Maimani.
Thank you, Chairperson. May I highlight the fact that what are we trying to test for here? We are not here to test for whether or not the report is valid or not valid, because there cannot be naturally an outcome where, as a process of this committee, we ourselves put the report on review. That's not the job, that's not the task. The task that we've been set up to is accepting the report as has been done by the Constitutional Court, by Parliament, who have voted on it. The job now is for us to then continue the work from that point. Re-prosecuting the report and the authors of report could materially deliver a situation where we'd have to, in essence, either rewrite aspects of the report. And I don't think that is the job of the committee. So I really want to urge, Chairperson, given that this matter is in court, given that all of that, we need to accept the report that has been given to us by Parliament. If we go back, if we accept that as a principle, we can then proceed and not have to subject the authors of the initial report to a process where they have to come to this committee to discuss the very same report. So, Chairperson, I want to state that as Build One South Africa, we are of the complete view that let us take this report. That is the subject that brought us to this point, and let us proceed drafting the process, terms of reference beyond that, evidence leaders beyond that, and then move on to establish the veracity of what in fact happened and whether or not it meets the threshold as put forward. But the notion that we should now go back to, if you like, reinterrogating the report is really going to send us in a space where we've got the potential now to say, let's rewrite the first aspect. And I would disagree with that strongly. And I think that would be a bad precedent to set that going forward. Otherwise, in future, any other reports would then have drafters write it, put it to Parliament. It will come to Parliament. Once it's done, then a committee could simply say, come back again and re-represent your case, which I'm not certain that's the way we should go. So I submit to you, Chairperson, that we need to accept it. We need to move on from this point. And ultimately, there are bigger issues that we need to interrogate going forward. Thank you very much.
Thank you. So you agree with the legal opinion?
My view is that the panel should not come through. We should accept the report.
I was just summing up that you are agreeing with the legal opinion. Zungula, are you disagreeing with the legal opinion or you agreeing with the legal opinion?
I am in agreement that what we must do is that we must proceed. We must guard, Chair, issues pertaining to delay tactics, because I'm just picking up, it's as if there's a strategy to delay here. The meeting, we are now an hour into the meeting, and there's not much progress because we seem to be saying the same thing over and over again. But I want to emphasize the fact that the Speaker, Chair, when complying with the Constitutional Court order, if you read section or paragraph 9.3 of the explanatory affidavit made by the Speaker to the Western Cape High Court, it's very clear that the Speaker said, as the owner of that report, because the independent panel handed over the ownership of the report to the Speaker, in compliance with that court order, then referred the report to the impeachment committee. Now, if you read also the judgment, point 7 of the Concord order, which is the reason why we're here, the report of the independent panel is referred to the impeachment committee established in terms of the NA rules, and that is what has happened. So my suggestion, Chair, let's just accept that there's precedence in that for impeachment processes, evidence leaders are the ones who table such reports, not the independent panel who would have drafted that report. Chair, ndiyakucela khawusingqandele ezi tactics ozama udileya le process, because if it's not ngapha e-court through legal processes, kulapha ngaphakathi kule committee.
I will then move the Honorable Mngitama. Are you agreeing with the legal opinion that the panel should not come before the committee, that ourselves we are the owners of the report?
In total, Chair, and not only that, Chair, I want to appeal to you to be alive to the delaying tactics that seem to be creeping in this process. Chair, we receive a legal opinion which is absolutely clear, reasonable, rational, and we are now being told to seek more legal opinion upon legal opinion. That's irrational and a delaying tactic. We should not allow this committee to further delay, Chair. The nation is waiting for the truth to come out, and that accountability must be exercised. Chair, I'm appealing to you, don't allow this committee to get out of hand unnecessarily, and to basically achieve the objective of delaying further and further, so that we don't reach the
point of order.
You are disrupting me, Chief.
Honorable Mutama. What is your point of order, Honorable Dagmo?
My point of order, Chair, is the following: that as the Chair, you're allowing Honorable Zungula to imply that a perfectly reasonable proposal that we delay a decision of this matter until we receive the written opinion amounts to delay. We want due process, we want fair process, but yet you're allowing members to imply that an exercise of one's rights is an attempt to delay. That is not our intention. Our intention is fairness in this entire process. That's my point of order. Shouldn't allow him to just imply impunity.
But Chair, this is not a point of order. Please.
No, Honorable Mauto, please don't do that. Please. I have to
Chair,
listen.
it's not a point of order.
No, don't do that. Don't do that. Honorable Dagmo, you are saying that you want to delay a decision, and when someone interprets the delaying of the decision to be a delaying tactic, it can't be said to be out of order. So your point of order is not sustained. Honorable Tambi.
Thank you, Chair. I'm trying to bring this meeting to order, Chair, based on the fact that the item that we're dealing with was our own resolution, Chair. That said, ourselves as a committee, in consultation with the Parliamentary Legal Services, we shall write to the authors of the independent panel report to check whether they will avail themselves of appearing before the committee and presenting the report should the need arise. So what we are confronted with now, it was for us to hear whether this was done. Then what happened was for us to be given a verbal opinion, that is the view of the legal services. And what we did was to say, can that legal opinion be circulated to us so that we can then also have a view? Because it's honestly, Chair, in all fairness, he was reading. Some of us might have even missed what he was saying. So that's what we're proposing, not to say, and it mustn't be seen as a delay tactic, because we took a resolution and we must be able to say here now, are we revoking that decision as this committee? Chair, thanks for the opportunity.
Thanks very much, Honorable Malema.
No, thanks, Chair. I agree with the opinion given, and there's no need to sort of any other opinion. Those people handed over. You know, some people are adults for nothing. There was a handover. So when a minister of houses hand over a house to you with keys and title deeds, and then you have a situation in that house, you can't say, let me go into the minister to come and sort out my mess here in the house. It's your house. It's your property. It belongs to you. On several occasions, there were attempts to call those people, including citing them in the court papers. They said, we don't have any report. We don't know what you're talking about. If anything, go and speak to the Speaker of Parliament. We all know that. And because we all know that, this is just a cheap delaying tactics, which you must be ashamed of. When you are pointed at the right direction, just accept that, no, you are correct. Let's leave it. Those people are no longer there. They are no longer part of anything. You tell them this, they tell you, we don't want to hear nothing. You called us, we're at home. We said, do this work for us and hand it over. We didn't hand it over to you. And if anything, go and talk to the Speaker. It's as simple as that. So let's proceed without even allowing this kind of exercise that seeks to embarrass all of us in front of the nation. Thanks.
Thank you, Honorable Michalakis. Then I'll close the speakers list after Honorable Mahlatsi. I will not accept further hands on this. Then we are moving with a decision on this matter.
Thank you very much, Chairperson. I'll save you some time. The DA is in agreement with what appears to be the majority of the committee, which is in agreement with the legal opinion. The panel has concluded their work, and our job now is not to interrogate the report, but to interrogate the evidence that will appear before us in what happened at Phala. So the DA is in agreement with the legal report, which seems to be also the view of the majority of this committee. Thank you.
Thank you very much. The final speaker is Honorable Mahlatsi.
No, thank you very much, Chairperson. I had expected this delay in tactics, but I didn't think they'll be this low. I propose also that we commence because we have the report. The report belongs to us. If we continue like this as a legislature, we were creating something that we won't stop in future, whereby court will actually give us instruction in terms of how to implement our processes. So I propose that we continue. The evidence leader will be the one that presents this to us, not the independent panel. The independent panel has finished. Thank you very much, Chairperson. I submit.
All right. Thanks very much, honorable members. And I've listened to all the submission on this matter. That the opinion that was given by the legal services be accepted, and that the evidence leaders be the ones that will take us through the report, which is now our report as a committee. It has been referred to us by the speaker to be part of the work that we do here. Can I get the hands of those who agree with the opinion from legal services? And just to say, Honorable Mutambi, it was in the course of consultation with the legal services that this matter came to be. So we are building on the resolution that was taken last week. I said I'm not recognizing further hands for now, Honorable Gama. We'll get to the voting stage. Can those that accept the opinion of the legal services that the panel report not be presented by the authors, please raise their hands.
I'm raising my hand. I support that. The matter is closed.
All right. Tembinkosi, have you taken down the numbers of those that have got their hands up?
All of us except the ANC chair.
If I can just be given a moment, Chair, and if Advocate Mayor can also just assist. Thank you.
All right, just keep your hands up so that the table can take note of the that submission.
Chairperson, I'm in support as well.
We have noted your hand.
Thank you, sir.
Are you done, Tembinkosi?
Yes, Chairperson.
Can I ask the hands to be lowered? Can I ask for the hands to be lowered? I'm asking for the hands to be lowered. I haven't called for the next point. So if you've got your hand up, please take it down. Honorable Musa, please take your hand down. Thank you very much. The other side was that, Honorable Musa, please take your hand down. I've been asked, I don't know what you're voting for right now. The other view was that this matter be delayed until the legal opinion or further or the legal opinion is circulated. Can I get the hands of those that support that view? All right. Can you please take note of the hand? The hands.
Chairperson, what about those that want to abstain because of your?
I will come there. Please allow me to.
Just
if you want to abstain, then don't put your hand up.
Yeah, but you're not allowing us to even speak.
No, I'm not there. I'm still going through the process. Those that says that the matter be delayed, raise your hand. Take down the hand. Tembinkosi.
Honorable Chair, I don't seem to be recognized.
No, we are not recognizing now. We are in the middle of a voting, Honorable Musa.
Yes, but I'm voting for it to be delayed. Honorable Chair.
All right, your hand has been taken. Please put your hands down now. Tembinkosi has taken the hands. All right. These hands that I'm seeing are the ones that says it be delayed, correct? All right. We have seen all the. Correct. All right. We have seen all the hands. Please take down the hands. All right. Any member that wishes to abstain on this, raise your hand. Musa, you can't vote twice. You are spoiling your vote.
No. I'm sorry. There's been a bit of a issue here with my phone. Sorry. Sorry.
All right. Tembinkosi, you've got that?
Yes, Chairperson.
All right. Thanks very much. Can you give me the numbers in terms of those that support the legal opinion and those that want the delay and the abstentions?
Chair, just before I do that, can I just get an indication? I see the hand of Honorable Dagmo is up. It was up even when you asked for those that want to abstain, Chair. Just so that I provide the accurate number. Thank you, Chair.
His hand went up on, he was abstaining from this vote.
Thank you, Chairperson. On that note, Chair, we had 16 hands that said the committee should that said the report is of the committee and the committee should proceed. And there was 8 hands that said the matter should be delayed, and then there was 1 hand that of Honorable Cameron that abstained. Thank you, Chair.
Thank you very much, honorable members. The authors of the independent panel report will not be presenting the report to the committee. That will be taken by the evidence leaders. Thank you very much. The item on the minutes, it's now concluded. Honorable Dagmo and Honorable Matau.
Yeah, thank you. Chair, I had raised in regard to the opinion, which we have been indicated was still underway, that we could please get a deadline by which that opinion would be provided to the committee. That was an outstanding matter. And then I still have one other matter related to the minutes arising, if I could do that once this other issue is dealt with. Thanks.
Can you raise your other matter that you did not raise when you raised your original matter on the opinion?
Thank you, Chair. The second relates to I think it was the point under evidence leaders where the legal advisors talked to a potential conflict in regard to Advocate Ngalwana. I'd like to request that judgment which they refer to is made available to the committee for the record. The actual judgment which they refer to involving Advocate Ngalwana in his capacity as an acting judge. Thank you.
Right. Thank you very much, Honorable. And then I'll get the legal to indicate when they will finalize the legal opinion on the questions as contained in Resolution D. Honorable Matlaule.
Thanks very much, Chair. 2 points. The first one has been covered by Honorable Dagmo on the outstanding issue that relates to the minutes. The second issue, Chair, is for noting. You don't have to do anything about it. To say, Chair, the system you use draws a line that do not allow us to rationalize things. We would have wanted to abstain because there has not been a rationalized argument that convinces us to vote otherwise. But I respect how you handled it. We just wanted you to note that. Thank you very much.
All right, thanks very much. And I know, as you will know, even in the way that we vote in Parliament, it's yes, no, and abstain. That's generally the order of conducting a vote, and that's what will follow in this committee. So there'll be those that support, those that don't support, and then those that abstain. Thank you very much.
And he voted no himself. He raised his hand himself.
Yeah, because of the dilemma, Honorable
Mautu and Matlaule, please take your issues outside of the meeting. Legal, Mr. Prince, indication of when you will finalize the opinion on Resolution D now that you have the research that came through last night.
Thank you, Chair. Chair, we will be able to present a consolidated opinion by Wednesday, or deliver it by Wednesday next week, if that is acceptable by the committee.
All right, thanks very much. So that's the response, and if you could assist, if you could also assist with just circulating the judgment on that was referred in the last meeting by Advocate Ngalwana, when he was an acting judge, that will assist. I think the actual judgment we have it is just to circulate it to members. So
you.
members, the legal opinion on the president will be ready for our meeting next week. Honorable Swart,
Please note, Madam Chairperson.
No, I've seen your hand. Is it on this matter or it's a different matter? I would like to move to the
On this matter.
to the briefing on the High Court ruling.
On this matter, Chairperson.
Swart, Honorable Swart.
Thank you, Chair. I want to request the legal services to try and finalize that opinion earlier. It's not helpful to get it next Wednesday if we're meeting on Wednesday. We need to try and get it earlier. So, Chair, I'd request we'll probably meet again next week, possibly Wednesday. Can we not get it earlier? Otherwise, it doesn't help. We'll sit with the same problem that we haven't read, and this is going to be a very important and substantial legal opinion. Thank you, Chair.
Thank you. I'll work and ensure that the opinion is circulated before the meeting so that members have read it. We'll work with the team. If it means we work through the weekend, we'll do so. Honorable Daniel.
Thank you, Chairperson. Chairperson, I note you saying that you make sure that the report, the legal opinion, will be with us before the next sitting of this impeachment committee. I appreciate that. But technically speaking, the next when this report is going to be before us, it can be in the morning of the day of the sitting, which is not ideal. So please, Chairperson, what has just happened now is not really how we want to proceed in this committee, where we have to vote, rather consensus. And I think if you do ensure that it's not before 10 o'clock on the day that we meet, that we're getting it, and rather a few days before, for us also to be able to peruse and come back with an informed decision and opinion. Thank you.
Thank you very much. Legal services have had your pleas, and they will work to ensure that we have that legal opinion on this particular matter. Thanks very much. We now move to the next item, which is the briefing on the court judgment that was issued by the Western Cape High Court. Is it you, Mr. Prince, or is Suen?
Yes, Chair, it's me. I'm going to take the committee through the court judgment. Chair, I'm just going to share my screen and turn off my video. Sure, just to confirm that the screen is visible.
I can see it.
Sure, Chair. Chair, I'm going to not read everything, but I'm going to take the committee to the important aspects of the judgment. As you know, it deals with a lot of technical legal issues, so we will try our best to summarize what the court had said so members are aware of the different aspects and the different legal challenges. So I will start at paragraph 7. I think the committee members are all aware of the background, what led to this point of the judgment. So on 12 June, the president approached the Western Cape High Court on an urgent basis, seeking to interdict the speaker and chairperson from commencing an impeachment inquiry. The speaker abided in the matter, but the chairperson opposed the matter on legal grounds but did not make submissions on the president's guilt and innocence, that is regarding to the substance of the allegations against the president. The judgment of the Western Cape High Court, the interdict application was heard on the 15th and 16th of July 2026 before the full bench of the Western Cape High Court, comprising Lacranche AD JP, the acting deputy judge president, Francis J. and Davis J. The judgment was handed down on the 24th of July 2026. There are 3 judgments in the matter. Davis J. penned the second judgment, with which Lacranche J. concurred. They formed the majority. Francis J. penned a dissenting judgment. The majority and the minority agree on the following issues, and that is in paragraph 9. These issues were argued before the court, but the court were in agreement on these matters as follows. They agree that the court has jurisdiction to grant the interdict sought. that the report of the independent panel is reviewable. C, the interdict application is not rendered moot by virtue of the fact that the committee has already begun its preparatory work, because properly construed, the relief sought by the president was not to prevent the committee from continuing with its preparatory work, but rather to prevent the hearing of evidence so that a successful review will not be left hollow. D, the validity of the report is not res judicata because the Constitutional Court did not decide the particular issue. And E, the objections based on urgency, non-joinder, and abuse of process were dismissed. Chairperson, in paragraph 10, I draw specifically to the matter raised by the committee to the chairperson. The committee in its affidavit had objected to the jurisdiction of the Western Cape High Court. And some of the other respondents also argued that the committee's authority to proceed with the impeachment process flowed from the Constitutional Court's order referring the report to it, read with the amended Rules 129I. They contended that an interdict altering the impeachment inquiry would, in substance, suspend the operation of the Constitutional Court's order. In their view, only the court that granted the order may vary, rescind, or suspend it, and a lower court may not undermine an order of a higher court. Thus, according to these respondents, including the committee, the president was required to seek his remedy in the Constitutional Court itself. Paragraph 11, as stated, all three judges rejected the argument that the Western Cape High Court did not have jurisdiction to hear this matter. They all agreed with Francis J., who reasoned that the court was not asked to set aside the order of the Constitutional Court, declare that it was wrong, or sit as a court of appeal. Instead, the president sought to review the report. The Constitutional Court had not reviewed the panel's report, but referred it to the committee. The Constitutional Court stated that where a panel concluded that sufficient evidence exists to disclose a prima facie case, the matter must be referred to an impeachment committee for an inquiry unless and until the report is set aside on review. Francis J. held that this contemplated the possibility of a review of the report. Accordingly, he concluded that a review was competent proceedings of the Western Cape High Court, and hence interim relief ancillary to such a review was in principle within the power of the court. So as stated, the court dismissed the arguments on jurisdiction. With regard to the issue of the actual interdict, in paragraph 12, I set out the various elements that needed to be proven by the president to obtain an interdict, and that is, he needed to show that he had a prima facie right, open to some doubt, irreparable harm, that the balance of convenience favored him, and he had no alternate remedy. The three judges disagreed on whether the president satisfied these requirements. The majority concluded that the president didn't meet the requirements for an interdict, and his application was duly granted. With regard to the second judgment, which was the majority, which Locranze supported and was the majority, on the issue of a prima facie right, though open to some doubt, that is the legal requirement. The second judgment stated that in his review application, the president asserted that he has a constitutional right to due process, not to be subjected to an impeachment inquiry that did not comply with the requirements of the National Assembly rules. With regard to his due process right, the president made the following submissions. The NA Rule 129G required the independent panel to make a qualitative assessment of the information to determine whether sufficient evidence and not prima facie evidence exists to show that the president committed one of the Section 89 grounds of impeachment. The NA rules required the assessment by the independent panel to act as a buffer between the initiation of the impeachment motion, in terms of NA Rule 129A, and a full-blown inquiry by the committee in terms of NA Rule 129M, read with Rule 129I as amended by the Constitutional Court. The NA rules set a higher threshold than prima facie. The independent panel misconstrued its mandate and failed to apply the correct test, thus depriving the president of the protection provided by a buffer stage built into the NA rules. Davis J. stated that these questions are to be decided by the review court after a detailed analysis of the rules. Paragraph 15. The first judgment, which is that of Francis J., had concluded that the president's interpretation of NA Rule 129G was incorrect and that the independent panel's interpretation is correct. On that basis, it concluded that the president's prospects of success in the review were poor and found that he failed to establish a sufficiently strong prima facie case to secure an interim interdict. However, Davis J. disagreed with this approach and stated that this sets the requirements for a prima facie right open to some doubt too high, effectively requiring a clear right. So these are the two legal tests or standards that the court disagreed on as to which was applicable. The second judgment stated in the Constitutional Court of National Treasury versus and others versus Opposition for Urban Tolling Alliance and others, which is referred to as the outer case, that the other court held that an interim interdict against an organ of state should be granted only in exceptional circumstances and the clearest of cases. However, these requirements form part of the balance of convenience assessment on which the prospects of success on the merits are one factor. Just going ahead, the Constitutional Court did not raise the requirements of an interim interdict against an organ of state from a prima facie right to a clear right. The court reaffirmed the ordinary requirements of an interim interdict as set out in Settler-Holo. It emphasized that the risk of harm to constitutional rights set out in the Bill of Rights is an important factor. The second judgment was cautious not to make definitive findings on the existence of prima facie rights, as this was the function of the review court. The second judgment in paragraph 17, the second judgment also referenced the case of Eskom Holdings, where the Constitutional Court held that a court deciding to grant an urgent application for an interim interdict was not required to make definitive legal findings on novel and complex areas of law, but only needed to be satisfied that prima facie there was a basis for such a decision that would favor the applicant. For such a decision would be in the applicant's favor. The second judgment stated that this stance also applies to the matter. The case under consideration involved unprecedented matters that were of grave and high stakes. At this stage, the court was not required to determine if the president's interpretation of the rules is correct, but whether his interpretation is reasonably sustainable. The second judgment concluded that the president satisfied the requirements of a prima facie right of sufficient strength for an interim interdict. Paragraph 18, with regard to the requirement of irreparable harm, the second judgment stated, an applicant must show that they appear to have a right that will suffer irreparable harm if it is not protected by an interim interdict. The president argued that if an interim interdict is not granted, he would suffer irreparable harm immediately and directly from the commencement of the impeachment inquiry. If the report is later found to be unlawful on review and set aside, he would have been subjected to an unlawful impeachment inquiry. This is the very harm his review would have tried to prevent, and if the process is allowed to continue, the harm would be irreversible. He argued that if the interim interdict was not granted, he would personally suffer irreparable harm as he would be subjected to unfounded and defamatory allegations in front of the entire country and international community. The second judgment accepted this argument. It said the impeachment process is punitive and the president could face serious and permanent damage to his dignity and reputation. Davis J. held that if the impeachment hearings were to continue pending the review, the president would suffer irreparable harm to his reputation, which the review court cannot undo. She stated that the genie will be let out of the bottle. Going on to paragraph 20, The second judgment concluded that if the president's right to due process of law is to be effectively vindicated in the review, the holding of impeachment hearings must be halted pending the review. In paragraph 21, so accordingly, she did find that he met the requirements for irreparable harm. Going on to paragraph 21, the balance of convenience and the separation of powers issue. The principles set out in Archer require the court to consider separation of powers harm alongside with relevant harm when it weighs the balance of convenience. In this matter, the second judgment considered the likely impact of the interdict on the National Assembly's accountability function. It determined if granting the interim interdict would promote the object, spirit, and purport of the Constitution. The second judgment stated that the outer principles were developed in the subsequent case of ESCOM, where the Constitutional Court introduced a notion of a sliding scale in the weight to be attributed to the separation of powers factors in the balance of convenience inquiry. Paragraph 22. Davis observed that an interim interdict is likely to be granted in instances where the review court is required to consider highly policy-laden or polycentric decisions that fall into the domain of expertise of an organ of state and where deference is required from the reviewing court. In such an instance, an interim interdict preventing an organ of state from performing its functions will cause greater separation of powers harm. Conversely, where the review court is not dealing with highly policy-laden or polycentric decisions that call for less deference to organs of states, there will be less separation of powers harm. ESCOM stressed the fact that affected fundamental rights may play a critical part in the balance of convenience inquiry. The second judgment was of the view that the current matter dealt with the interpretation of the impeachment rules and the panel report in the context of a disciplinary setting. These are factors within the court's expertise and do not require deference from the review court. In this instance, there is likely to be less separation of powers harm if the interdict is granted. Davis-Day stated that the temporary stay of an impeachment hearing would not significantly impair the National Assembly's accountability function. The court is the guardian of the Constitution and must ensure that other branches of government act lawfully. All state power must be exercised lawfully, and the National Assembly cannot hold the president to account by acting unlawfully. Paragraph 25. The second judgment disagreed with the first judgment, finding that separation of powers harm will flow from an interim interdict, which restrained the legislature from performing its core functions to hold the president to account. And at the same time, when the Constitutional Court has directed that the impeachment process proceed. Davis-Day indicated that the Constitutional Court had no bearing on the separation of power issue. The effect of paragraph 7 of the Constitutional Court order did not more than refer the report to the committee established in terms of the rules, but it did not dictate how and when the impeachment inquiry should be conducted. In paragraph 26, further, the second judgment disagreed with the view that a temporary stay of the impeachment hearing will significantly impair the legislature's accountability function. The review hearing is imminent, having been set down for 2nd to the 4th September 2026, and the judgment may reasonably be expected to follow in short order. A delay of a few months does not amount to significant separations of power harm. This is in light of the fact that the allegations against the president first surfaced in 2022, and there were delays in litigation related to the matter for which the president cannot be held responsible. According to Davis-Day, the worst case scenario is that the committee will commence its impeachment hearings in February 2027. However, in her view, this does not amount to significant separation of powers harm that trumps the president's right to dignity and due process, and the need to preserve the stature and functioning of the office of the presidency. Paragraph 27, J noted that a consideration of these fundamental rights must play a critical role in the balance of convenience inquiry. Given the importance of the president's rights and the harm he faces if these rights are not protected, any separation of powers harm caused by a temporary delay in the impeachment hearing pales against the risks of significant and lasting harm to the president. Further, consideration must be given to the fact that the functioning of the presidency will be impaired by the impeachment hearings if the impeachment hearings continue, and the stature and standing of the office will be harmed. The national interest requires stability in the functioning of the presidency. Davis J. was of the view that the disruption caused by the impeachment hearings should not be allowed to happen if there is a prospect that the impeachment process may be set aside as unlawful. With regard to balance of convenience in paragraph 28, the second judgment held that the balance of convenience favored the president. Davis J. reasoned that the proceedings with impeachment hearings, proceeding with impeachment hearings while there is a challenge to the validity and lawfulness of the report will cheapen the rule of law. Even if the report were set aside at a later stage, the efficacy of the rule of law would have been weakened, and public confidence in the rule of law will similarly be weakened. Davis J. was of the view that the legislature's accountability function cannot be prioritized above the rule of law. She stated that Parliament was required to comply with the law in the exercise of its accountability function, and the value of accountability cannot be prioritized at the expense of the rule of law. With regard to the element of no alternate remedy, an applicant must prove that without interim relief, there is no satisfactory legal remedy to redress the harm. Davis Day noted that the president seeks to avert harm to his dignity and reputation, and the violation of his rights cannot be subjected to an unlawful impeachment inquiry. She held that these can only be protected by interdicting the continuation of the impeachment hearing pending the review. In the event that the report is later found to be unlawful, the president cannot at that stage vindicate his right, as the genie will be let out of the bottle. Accordingly, the president met the requirements of the absence of an alternate remedy. The second judgment concluded that the president had met the requirements to be granted an interim interdict and made the following order. A, pending the determination of this court of the applicant's review under case number 2026-119182, the first and second respondents, that is the speaker and the chairperson, are interdicted from proceeding with the public impeachment hearings in terms of Rule 129M of the National Assembly Rules. B, the cost of the application shall stand over for determination by the court which hears the review. Chairperson, the third judgment largely agrees with Davis J, and I'll just refer to paragraph 35 as I will not repeat the elements where the court agreed. Lagrange J therefore supported the second judgment as it strikes the correct balance between preserving the president's right to due process, protecting the integrity of the office of the presidency, and ensuring that the impeachment process itself, if it proceeds, does so on a lawful foundation. So, Chairperson, that formed the majority judgment. The first judgment, which is that of Francis J, also went through each of the requirements for an interim interdict. And in paragraph 36, just in the middle, it says, Francis J was of the view that it was reasonable to conclude that the panel did not misconstrue its mandate, and the panel's interpretation of Rule 129G was consistent with the structure and purpose of the impeachment rules. Accordingly, he concluded that the president failed to establish a prima facie right of sufficient strength to justify interim relief. The rights he seeks to protect rest on the prospects of his review application. However, his review grounds were weak and did not have the prospects of success. With regard to irreparable harm, the first judgment acknowledged that while the president may suffer harm, it was not irreparable. The impeachment process had numerous procedural safeguards at each stage to ensure fair process. Further, the NA may only remove the president with a vote supported by 2/3 of its members. Any harm to him is therefore not immediate or irreversible. Secondly, the allegations in the report have been public since November 2022 and were unchallenged for 4 years. The president took 5 weeks to bring his interdict application to protect him from what he claims is irreparable harm. Francis J. acknowledges that once the impeachment process commences, evidence cannot be unheard and political momentum cannot be reversed by successfully reviewing the report. However, the impeachment inquiry has no automatic legal consequences for the president. If the review is successful, the court may set the report aside and make a just and equitable order. Thus, the president could be vindicated, but at a later stage, and therefore he will not suffer irreparable harm. With regard to the test of the requirement of a balance of convenience and the issue of separation of powers, Francis J. was of the view that granting an interim interdict would result in separation of powers harm, as the NA would be restrained from exercising its constitutional accountability function in Section 89 of the Constitution, and the committee would not be able to fulfill the order of the Constitutional Court. Francis J. was of the view that even though the review application is to be heard in September 2026, an interdict of a limited period will result in separation of powers harm. Further, there was a possibility that the president may seek further interdicts pending appeal, suspending the committee's work for years. The court acknowledged that if the review later succeeds, the impeachment inquiry may take place on an invalid foundation, and parliamentary time and public funds may have been wasted. However, the court considered these public costs less significant than preventing Parliament from carrying out its constitutional duties and effectively suspending the operation of a constitutional court order. With regard to there being no satisfactory remedy, Francis J. was of the view that the president does have alternate recourse. The review application will be heard in September 2026, and the court can set aside the report and any steps taken under it. During the impeachment inquiry, he may contest the evidence and put his case with legal assistance. If the report is ultimately found to be unlawful or defamatory and set aside, that outcome itself will provide vindication. According to the above reasoning, Francis J. was of the view that the president failed to make out a case with an interim interdict. As we've indicated, the president was granted the interim interdict. We come to the issue of what are the implications of the judgment for the committee. In paragraph 41, the committee is interdicted from proceeding with public impeachment hearings in terms of Rule 129M of the National Assembly rules until the president's review application is determined. In interpreting the above order, we are of the view that public impeachment hearings relates to the hearing of evidence, including the hearing of testimony of witnesses and considering documentary evidence. On our interpretation, the committee may continue with preparatory work that does not involve the hearing of evidence. The preparatory work may include the appointment of evidence leaders, finalizing the terms of reference, and preparation for the inquiry. Conclusion, it is our view that the committee is prohibited from commencing public hearings as provided for in NA Rule 129M. However, the committee may undertake preparatory work. Thank you, Chairperson. That is the summary of the judgment and our views on the implication for the committee.
Thank you very much, Suen. If you could just maybe, especially the last part where you are, if you can just keep it flighted for now. Honorable members, I now invite questions and comments. And once the questions and comments have been shared, I'll also just offer a view. I see only two hands, that of Honorable Swart and Honorable Mahlaule. Oh, I see now they are coming. Honorable Swart, you can deposit your question and or inputs.
Well, firstly, Chair, from our perspective, we'd like to thank the legal team for the presentation of the judgment. which the judgments which we respect. I would like to engage, Chair, with the committee and the legal team on the question of appealing the interim interdict that was granted by the committee. And I'm appreciative of certain political parties that have indicated that they do intend appealing. And I would briefly like to argue why, from the ACDP's perspective, we believe this judgment, the majority judgment, should be appealed. Firstly, Chairperson, as Judge Lekranji pointed out, the issues in this matter are grave and the stakes are high, and it is uncharted territory. Now, Chairperson, in our letter, our first letter at the beginning, we indicated this is uncharted territory. That's why we urged the Speaker to oppose the interdict. You correctly opposed it. But, Chairperson, this is a precedent-setting judgment. It is very important. This is a full bench judgment, although there was a dissenting judge, and it will determine and influence all future impeachments should it not be appealed against. Chairperson, it's very important, as indicated by the legal advisor, the higher standard when we're dealing with separation of powers, when we're dealing with impact on Parliament, and the issue of the clearest of cases as set out in the ARTA and ESCOM judgments. That is, besides the issues relating to the very important arguments of jurisdiction and, of course, the compliance with requirements for an interim interdict. Chairperson, possibly the strongest argument of why this judgment should be appealed by this committee, by yourself, Chairperson, representing the committee, is the issue of delays, possible delays. The public are demanding to know what happened. And here, it's very clear that in the minority judgment deals with the issue that this matter could be delayed for years. And we're not satisfied with the majority judgment where it says until February 2022, next 27. Chairperson, it is indicated the judgment says if there is appeals, and the President has already indicated in his reply affidavit, he has considered the possibility of appealing against the review application, which would delay us on the basis of this interim interdict for possibly years. Now, Chairperson, the last point is, in terms of the Superior Court rules, in order to apply for leave to appeal, you need to have a reasonable prospect of success that another court will come to a different view. And the very fact that we have a dissenting judgment here of Francis pointing out these issues indicates a strong possibility of the full bench granting leave to appeal and another court coming to a different view, the Constitutional Court. Therefore, the ACDP argues strongly that this judgment should be appealed against. Thank you, Chairperson.
Mr. Chairperson, do recognize me as well. Thank you.
I will recognize you down. Honorable Mashauli.
Thank you very much, Chairperson, and we note the advice by the legal services to the committee, which stipulates that the judgment did not interdict the preparatory work of the committee, but only the public hearings. If you look at the actual text, the court held the committee is interdicted from proceeding with public impeachment hearings in terms of Rule 129M of the National Assembly rules until the President's review application is determined. Now, our view is that the opinion provided does not analyze the implications of the ruling in its application. For instance, it does not indicate how the committee should treat the order that Rule 129M, which is powers and functions of the committee, is interdicted, and which elements of the powers and functions of the committee are interdicted? And to what extent should the committee exercise its powers and functions as envisaged in Rule 129M? In this regard, Chair, it bears a question that says, amongst other things, what is meant legally, in this opinion, by the words public hearings? Our legal must help us in understanding that. Two, the legal opinion does not explain what the parameters of the preparatory work of the committee will be. For instance, what becomes the role of the evidence leader after appointment? Will the evidence leader have consultations with witnesses? If so, does this have the effect of starting the public hearings or not? How do we separate the consultation and taking of witness statements by the evidence leader from the actual public hearing? The two are not mutually exclusive. It is not part of the public hearing processes. The court has further interdicted the implementation of Rule 129M, which regulates the powers and functions of the committee in terms of the NA rules. The committee, through its preparatory work, is exercising its powers and functions, with no doubt, which, according to the judgment, has been interdicted as per the Rule 129M. Considering that Rule 129M has been interdicted, what does it mean for the committee exercising its powers and functions? What are the parameters of powers and functions as provided for in Rule 129 of the committee in the context of the preparatory work and public hearings? What is the committee to make of the interdict to Rule 129M, which is powers and functions of the committee? Lastly, Chair, we are of the view that you should not file any application to the High Court because this is a ruling that specifically says it's not for a long term. It's I just forgot the word they inserted there, but it's not for a long. It's a temporary relief. So we are of the view that you should not appeal. The committee should not appeal this judgment of the Western Cape High Court. Thank you very much.
Thank you, Honorable Mahlaule. I think the next speaker was Zungula, but before Zungula, Honorable Zungula comes in, I will ask Honorable Mautwe to just briefly stand in for me for a bit of a human right break. And then after Zungula, in case Zungula finishes before I return, it will be Honorable Mahlatsi. So, Honorable Mautwe, if you could just please stand in for me, I'll be back shortly.
Noted, Chair. Thank you. Let's go to Honorable Mahlatsi, Dr. Wanda Mahlatsi. Over to you.
No, thank you very much, Chairperson. Chairperson, firstly, I believe that the committee should challenge the outcome of this of the High Court. There are parties that the other respondent, like Honorable Zungulu, the ATM, the EFF, the NKP, and the UAT, who have filed application to leave to appeal directly to the Constitutional Court. Now, the split decision, it creates more uncertainty. And these are the points that the UAT want to present to the committee, that the delay caused by the judgment may run into years if possible appeals are taken into account. The limits often extend to which that the courts can prescribe to Parliament how to do its work must be clearly defined. What Parliament is allowed to do as preliminary steps is not clear. For example, can witnesses still be called if they are not going to testify in public? That's a question. Since the Speaker is abiding because she is referred to the report to the committee, it is the duty of the committee to defend the Parliament from judicial overreach. The decision to appeal is only a logical step in the implementation of the committee's earlier decision to oppose the President's application. The political parties will present their partisan stance, whereas the committee will be more objective and represent the general public. So I'm putting it forward. I propose that the committee must appeal this decision to the Constitutional Court. Chairperson, I submit.
Thank you, Honorable Mahlatsi. We now move to, on my screen, it's Honorable Andile. Over to you, Honorable Andile Mkutama.
Chairperson,
Thank you,
I'm
Comrade
sorry,
Chair.
you recognize me as well.
Noted, Honorable Dr. Hlope, you are recognized.
Thank you.
Yes, I recognize all the contribution by colleagues, and I'll restrict myself only to emphasize the one point, which is that this committee must indeed lodge an appeal. We have a responsibility to protect the integrity of this process and to ensure that the president does indeed account. It will be a dereliction of duty if we were not to do so. So align myself to the call that this committee must lodge this appeal. Of course, the one key matter which must be clarified is the powers of the different courts. We are sitting with this anomaly where a lower court, in effect, has variated the decision of the highest court in the country. And that matter must be clarified by the highest court in the country as to whether its decisions can be second guessed and variated by lower courts. It's a very, very important matter which must be clarified, and this appeal will help the nation to resolve that matter. I thank you, Chair.
Thank you, Honorable Mkutama. We now move to Honorable Ngola.
Thank you so much. I am largely covered by Honorable Mahlaule. Chair, I think in the advice, if you go to paragraph 42, there the advice actually does detail, or rather tell us what do they mean when they say the committee may continue with preparatory work that does not involve the hearing of evidence. They go further and explain that this may include the appointment of evidence leaders. But there is a last part that they speak about the preparation of the inquiry. If they can enlighten us in that respect, that what does the preparation of the inquiry entail, so that we are able to balance whatever we do with what the High Court, the Cape High Court has decided on the interdict application. I want also to check that as we move with the appointment or the recommendation for the appointment of the evidence leaders, will we be what financial needs will we then need immediately after the evidence leader will be appointed, and what work in the interim that the evidence leader will do? And because if you check and read the report, it does say, I think all the three judges does confirm that the report of the section 89 independent panel is reviewable. So I want us to balance the work we are trying to do with what the Cape High Court has done without spending too much, because it will be a fruitless expenditure if we are to spend too much on the work of the evidence leader, and at the tail end the report is reviewed successfully. So I wanted also to check that. And also, Chair, I agree with Honorable Mahlaule that from where I'm seated, we are under no legal pressure to appeal what the Concord has said. Chair, the Concord has not barred us from doing work. If you check the text of the judgment itself, it only limited us to a certain aspect until the review application is heard, which will be heard beginning September. And if you check, we are that will be about slightly above 30 days. So I don't think we are suffering any legal harm, Chair, if we don't file an application to appeal the rule NESI. It has been, Chair, for quite some time, been said that an interim interdict is generally not appealable except only on extreme circumstances. So I think, Chair, given the fact that this is a rule NESI, an interim order, so we have this quite short time to be dealing with the in-house issues. We're under no legal pressure to file for an appeal. Thank you so much, Chair.
Thank you, Ngola. As I call Honorable Vessels, I'll be handing over back to the chair. That's hands. I'm Tulo. Thank you.
Thank you very much, Honourable Chairperson. Let me firstly also welcome the Legal Services opinion and summary of the judgment, and that is appreciated. Chair, I'm not of opinion that we should, as committee, appeal this interdict. I am of opinion that it's an interim interdict. On Bongola is mistaken. It's not a rule NESI. A rule NESI would mean that there's then the respondent has a return date to show cause why it should not be made permanent. This is, in effect, the opposite. It is an interim interdict, and the court had a long discussion on the matter of further appeals after the review application is heard. And I think it's a balanced approach and a conclusive on the fact that it will not delay accountability without any prospect of that occurring in the near future. It is the review application set for early September. And in those terms, our prospect of success of appealing this interim interdict is very, very low. We will not be able to show cause that there's real harm to accountability and that there's a permanent stay and that there's a stay in totality. I do also disagree that the court interdicted our functions and powers in terms of Rule 129M. The court is very clear that it interdicted public hearings in terms of Rule 129M. That does not mean that Rule 129M in totality is interdicted. That would be an absurd interpretation of the interdict order. And thus, I agree with the legal opinion and the interpretation that we are allowed to continue with our preparatory work, and we should continue with it. I also disagree that that could be fruitless and wasteful expenditure. I think that would be an overreach to say, let's stay our procedures now completely until the president's review application is heard. It is also not, I don't want to go into all those legal arguments, but obviously if one reads the majority judgment of the Constitutional Court, the court says that this report by the independent panel, if it finds prima facie evidence sufficiently so, that it goes to an impeachment inquiry in terms of Section 89. Unless a court sets aside the report, and that is in the judgment. And thus, I also don't agree with the jurisdiction arguments and the argument that the lower court now overruled the higher court. The Constitutional Court did not pronounce itself on the validity of the report and said that the report may be set aside by a court. And that's the only way that a Section 89 independent panel report is adjudicated upon. It took away the power from the legislature, who can decide if a report is faulty or defective or not, and we had that discussion earlier, but it took away that power from the legislature and put it in the judicial sphere and said that the judiciary should decide if a report is defective or not, and it did not pronounce itself on the nature and on the validity of the report. That is the review application now. But Chairperson, practically speaking, without getting enstrangled in all the legal arguments, practically speaking, there wouldn't be no sense to appeal this interdict now, as if we continue with our preparatory work, we adopt our terms of reference, we go through the process of the adoption of evidence leaders, and the work starts with preparing all the preparatory work that can be done by the evidence leaders then, which do not entail public hearings. We know, practically speaking, if we look at other inquiries, previous inquiries historically, committees, ad hoc committees, and so forth, we will not start, interdict or no interdict, before October with public hearings, if it is as soon as that. We know that practically. So practically, it's going to be a moot exercise to appeal this interdict. The court has a reasoned approach to this, and I would oppose that the committee appeals the interdict, and I also believe we can continue with our preparatory work, and we should continue with that. Thank you, Chair.
Thank you very much, Honorable Vessels, and thank you, Honorable Mauta, for standing in for me. Honorable Hlophe.
Thank you, Chairperson. Thank you for your indulgence. Firstly, I fully agree with the view that we must carry on with our work, which is preparatory in nature. And as Honorable Vessels has quite rightly pointed out, we are not likely in any event to start engaging with public hearings anytime before October, but preparatory work must carry on. Now, Mr. Chairperson, allow me to make my final contribution. It relates to the question whether or not the impeachment committee should appeal. We spent a long time deliberating on this issue. We deliberated at length. The reasons that existed at that time, when we concluded that you, as our chairperson, must oppose the application, have not fallen away. Nobody here has argued that those reasons have fallen away. If anything, the uncertainty has been created, certainly, by the fact that there is a dissenting judgment. And my view is that the dissenting judgment is more legally persuasive. It is correct. The majority of the judges saw it differently. Once you decide to embark on litigation, it carries with it the risk that you may lose before the initial hearing. And a wise man or a woman would carry on and appeal. And in short, we have already deliberated at length on this issue. We were sober-minded when we decided that we should oppose the litigation. We did that, we opposed it, the court ruled against us. Logically, I would urge this committee to appeal against the ruling of the majority of the Western Cape High Court. I submit. Thank you very much, sir. Chairperson, thank you.
Thank you very much, Honorable Maimane.
Thank you, Chairperson. I think without delving into the merits of the argument that were being presented both in the majority judgment and the dissenting judgment, the question of reputational harm in the person of the president, of course, all of us as citizens have an interest in that matter. And therefore, I think the president is well within his right to advance that argument. But equally so, there is a question about the fact that the Constitution makes it clear that the president's duty is to protect national unity and furthermore be the representative of the people of South Africa. We as Parliament have a job here to protect the integrity of where the people of South Africa are at. And so to some extent, we have to equally so be able to say, what about the harm that the people of South Africa equally face in this matter? Because it's crucial for all citizens to get to understanding what in fact took place. I would argue that I think the president would be able to come and clarify the matter in committee, etc., in going forward. Therefore, I think on balance of those and on future prospects of any of these matters going ahead, I think there's something amiss. Whilst I hear what Honorable Wessels is arguing, I want to support what Honorable Swart argued earlier, which is to say that if one arm of the state was able to interdict another, then I would argue that the people of South Africa then are subordinated to then the argument of the arm of the state. And we here, in our, if you like, we stand with the people, and we have the reputation of the citizens of South Africa to protect. And the citizens of South Africa have a primary interest in being able to understand what took place, what happened, so that they can get clarity. Our view is that whilst I hear that public hearings will resume in October, etc., point is taken. But the sooner we can get over this matter, the better it is not only for the president, but for the people of South Africa, so that our global reputation is protected. Because it doesn't make sense if you look at it outside or independent of all the players. If you were sitting in a foreign country and asking what's going on in South Africa, you are not discussing South Africa's economy or anything. You are discussing whether the president of South Africa is facing impeachment or not. And I'm not sure that serves the interests of South Africa. So in the interest of being able to get through this matter as quickly and as effectively as possible, I would urge Chairperson, as Honorable Schwartz has already advanced, that we need to appeal this matter. And we need to be able to set the precedent for any future proceedings that will take place in this matter. Otherwise, it will be the same movie for another president where it will occur again in future. I support Chairperson. Thank you.
Thank you very much, Honorable Direko.
Thank you, Chair. Chair, in supporting the point raised by Honorable Mutlaule, I believe that the committee requires a greater legal clarity regarding the scope of our work in terms of the court ruling. If we could just get a clear understanding as to what is it that we're expected to do and what is it that we are not supposed to do going forward regarding the court ruling. It will also assist us to map a proper way forward with regard to our scope of work from now until the day of the review. Secondly, Chair, I do not see any need for us to appeal. Allowing the review application to be heard first has potential to safeguard the integrity of Parliament, because previously we had appealed and we lost the appeal, which then deals with the credibility of the institution. We can't be a Parliament that keeps on losing cases. Secondly, Chair, we also need to note the fact that the order is temporary and appeal may not be necessary because the interim order will fall away once the review order is decided by the court. And if there's any need, then the committee can then continue doing their work. And lastly, Chair, we also need to look at the issue of the cost. If possible, we need to avoid unnecessary legal cost. For an appeal will require additional cost, and it will also cause a delay on the matter even further. And previously, when we were dealing with the minutes, you then indicated that some of the processes that you are following are causing a delay on the process. So appealing may also result to the delay that we said we don't want. So that is my submission, Chair. Thank you.
Thank you very much, Honorable Zungula.
Thank you, Chair. Hearing, Chair, the inputs by my colleagues, I think it is I think the main reason why we must appeal this judgment on various grounds, including the fact that it is a vague judgment. A vague judgment becomes difficult to enforce, difficult to comply with, and causes more confusion. And it then warrants that we approach the Constitutional Court for clarity purposes as to how Parliament and the committee must operate and fulfill its constitutional functions. The other issue I want to raise, Chair, when we took a resolution to oppose the interdict application, the principles that were prevalent at the time was to protect the constitutional mandate of the committee and the authority of Parliament. Those principles have not changed. Therefore, continuing with their appeal is in effect fulfillment of the resolution that we took as a committee. Now, if we then decide not to appeal, it is akin to us as a committee. It is akin to basically abandoning the very same resolution we took. Hence, my submission is that we must appeal the judgment that was handed down on Friday, particularly because the order creates precedents. Whilst the matter at hand now, it is President Ramaphosa, Phalaphala, etc. But this judgment that was handed down on Friday is not going to be confined to this particular case, this particular instance. It is going to impact other public office bearers in terms of how an impeachment is handled when there's impeachment proceedings against them. Now, to have a split judgment becoming precedent, it becomes something that we as the committee need to guard against. Hence, we must go to the Constitutional Court as a committee to ensure that the precedents that will be followed in future when it comes to issues pertaining to impeachment, interdicts, etc., it is not something that could be challengeable in the sense that a split judgment obviously shows that there are differing opinions, and the split judgment came from the Western Cape High Court. It did not even come from the highest court in the land. So, based on those reasons and grounds, I'm of the view that we must challenge and we must appeal, particularly the impact, the fact that even now there's no clarity. I think Honorable Mahlaule spoke about there's no clarity in terms of what is the extent of the work that could be done now. And I'm raising or bringing you closer, Chair, to the aspect that says the interdict is on the public impeachment hearings. Now, what is a public impeachment hearings? Because here we are in an impeachment committee. Now, this impeachment committee, at this particular stage, it is busy with the work of determining evidence leaders, terms of reference, etc. The next step will be obviously getting the evidence. Now, when the judgment says the public impeachment hearings are interdicted, now, what if a person makes an argument to say, but let's proceed. However, we don't do anything in public. We have hearings, but they are not going to be in public. That would be in violation of Section 59 of the Constitution, which mandates that the National Assembly must conduct itself in a manner that is open and answerable to the public. So in this particular case, one can argue that the order handed down on Friday would be in violation of the Constitution, and only the Constitutional Court can be able to provide clarity on that particular assertion, including the view pertaining to separation of powers. And let me come now, Chair, to the issue pertaining to the practical effect of the delay. Whilst people are saying that this delay or this interdict, it's up until September or so, that is not in the order. The wording of the order is saying respondents 1 and 2 are interdicted from proceeding with public impeachment hearings until the determination of the review application. Now, the review application, that on its own does not necessarily mean that it will be done in September, because the case is going to be heard in September in Western Cape. And as the president has already indicated, should he lose, he's going to appeal. Now, it means he can use the very same principles, very same precedents that would have been set on this particular interim order that was handed down on Friday as a reason to say the process must stop. And when the process stops, when it goes to the appeals, as the members have said, it is not going to be just few months. It has got the practical effect of being years. And I not remind you, Chair, previously we went with the EFF to the Concord in November 2024, and the judgment was only handed out down in May 2026. So that shows the extent of the delays that we're talking about. So it is not something that is amiss, or it is not just being fearful when we're saying that the delays can take years. We've already seen it with the Concord judgment, which came after more than 15 months. So it is important, Chair, that we must appeal. We must, for certainty as to how the committee can proceed, but most importantly, for precedent's sake, so that we avoid a case whereby the precedents that will be guiding the impeachment processes of Parliament are coming from a court in which the 3 judges, even themselves, were not in agreement as to how, were not in agreement, or were not, it was not a unanimous decision as to this is the law and the law that must be final. Because even in another case, Chair, when it came to, I think it was a Godan case, where the Constitutional Court ruled that when there is going to be an interim interdict that affects or impacts a state functionary, in this particular case, it is Parliament, the court hearing that particular matter must be able to pick to the review or pick through the review application and ascertain whether that review application has got prospects of success, in which the majority judgment handed down on Friday did not do so. The minority judgment did so and concluded that there is poor chances or poor prospects of success for the review application by the president. So in those grounds, Chair, there is more than enough reason for the committee to appeal based on the various grounds, on the vagueness of the order, the practical effect that now Parliament will be immobilized for months, in the sense that it will be unable to fulfill its constitutional obligation of holding the president accountable for, it's going to be difficult, it's going to be immobilized for a period greater than the month that people are talking about. The last thing I want to say is that there is a need to protect Parliament's right to hold the president to account. Whilst he has a right as a person, also Parliament, on behalf of South Africans, also has a right to hold him accountable. And this was confirmed by the Constitutional Court in the Nkandla judgment. However, the 2 judges in the Western Cape High Court ignored this binding judgment last Friday. So in those words, Chair, I'm of the strong view, and I second the motion and the proposal that we must appeal. Thank you.
Thank you, Honorable Mautu, and then I'll come to Honorable Breitenbach, Honorable Daniels, Honorable Mpapani, Honorable Kwankwa, Honorable Dagmo, and conclude with Honorable Mtam. Honorable Mautu.
Sorry, Chair, I also raised my hand. Honorable Ngobeni.
All right, I'll note it. I don't see the hand on my side. All right, now I see it. Thank you.
Okay, thank you. Thank you, Chair. Chair, it's our view that the Western Cape High Court got it wrong. And we are saying this with the utmost respect. And therefore, the logical thing to do would be to appeal. Because as Honorable Swartz has said, this is a precedent-setting process. And therefore, we might not do it for ourselves, but do it for the future. So, Chair, the Constitutional Court should provide a definitive clarity on the meaning and legal effect of Order 7 of its own judgment, particularly whether the referral of the independent panel report to the impeachment committee was intended to be a mandatory constitutional directive that required immediate implementation. The EFF's appeal argues that the Concord did more than merely transfer the report to another institution. It actually directed that the report be processed in accordance with the National Assembly rules through the impeachment committee. Now, the uncertainty created by the High Court's interdict, therefore, strikes at the heart of what the Constitutional Court intended when it restored the impeachment process. Number two, the constitutional issue concerns the separation of powers, and I think a lot of colleagues did raise this. As Parliament, we have an exclusive constitutional responsibility under Section 89 to hold the President accountable. The appeal contends that the High Court's order effectively disables Parliament from exercising that constitutional function, despite the panel report remaining valid and operative until set aside by a competent court of law. So the interdict therefore raises the broader constitutional question of whether the judiciary may restrain the legislature from performing one of its core constitutional functions at the request of the very office bearer who is the subject of the accountability process. According to the appeal, Chair, this constitutes an unprecedented intrusion into Parliament's exclusive constitutional domain and undermines the constitutional principle that each branch of government must be allowed to perform its assigned functions. Lastly, Chair, the court should consider the practical implications of permitting the President's litigation strategy to continue. If every stage of the impeachment process can be suspended through successive review applications and interim interdicts, the constitutional accountability mechanism may be indefinitely delayed. The appeal warns that such a Stanley-Gred approach would frustrate the purpose of Section 89 and weaken Parliament's oversight role and create a precedent enabling future presidents to delay accountability simply by initiating further litigation, thereby undermining the effectiveness of the constitutional impeachment process. It is for these reasons, Chair, that we feel very strongly that we need to seek this guidance from the Concord that should assist us and intervene so that we don't delay this matter forward. We've got matters that are going for 17 years in this country. Or is that something that you want also to be done with us in Parliament? Of course, we respect the fact that every person has got the right to be heard and the right to the law, to legal representation and everything. But is this what we want, even after being given guidance by the Concord that this matter must be referred to the impeachment committee without any delays? So that will be our submission, Chair. We strongly support the notion that says that we should appeal this matter, more so that we have not yet gotten the relief that we sought to get when we first debated this matter as the committee and we took that resolution that we must oppose this matter. I thank you, Chair.
Thank you, Honorable Breitenbach.
Thank you, Chairperson. Good morning to everybody. Forgive me, Chair, I'm driving and so it's difficult. But I'm persuaded, Chair, having initially been of the view that that we should not appeal. I'm persuaded by the arguments of colleagues that that perhaps we should appeal for the reasons already set out and which I don't want to repeat. Simply, even if the review application has been finalized and even if we can then proceed, it may well be healthy in terms of the law going forward to get a proper evaluation of this judgment, because it's correct that the judgment is somewhat ambiguous and vague and does encroach on the powers of Parliament in a fashion that may well be going forward unacceptable. So we will support the move for an appeal, Chair. Thank you.
Thank you very much, Honorable Daniels.
Thank you so much, Chairperson. Chairperson, looking at what's before us, it is quite clear that this order comes with an important practical qualification. Because although the committee could technically meet for administrative purposes, we need to note that any meeting that goes beyond neutral housekeeping would be highly vulnerable, Chair. We must be cognizant that a court would look at substance and not terminology. So if we are going to lean towards something calling a preparatory meeting, would not protect it if members begin to consider evidence and testing allegations and issuing substantive directives or preparing conclusions for that matter, Chairperson. And I'm speaking directly to you as the chairperson of this because you are leading this committee, Chair. You know, my understanding is that we may not, as been mentioned before by other colleagues, convene public impeachment hearings as per the order, hear oral evidence, interrogate witnesses, or even as much as interrogating the president, receive evidence through processes masquerading as a briefing or preparatory meeting. We may not deliberate on credibility or merits of evidence already presented, Chair, and advance a substantive inquiry towards findings or any recommendations for that matter. Those are the things that I read that we are not supposed to do, Chairperson. Now, like I've alluded to earlier on, the committee's adjudicative function is suspended on an interim basis until the review application is heard. Now, my submissions here, Chair, that I'm making must not be seen as protecting an individual person. We are protecting the process and the record that has to survive a court. So I want to say, Chair, we or yourself as the head of this committee, I want to make it known to you, Chairperson, that as a Patriotic Alliance, we want to discourage you from considering to challenge this order by appealing the interdict court ruling. There's just a few weeks, 4 to 5 is my guesstimation, weeks left before the review application is before the court. And for as much as we are confined by the order to stick to preparatory work, I think we've got enough to do in this next month and a bit. And therefore, there is really no urgent need for us because everything hinges on the outcome of the review application first week in September, which is a few sleeps from now, Chair. And because everything hinges ultimately on that outcome, there is no need for us to go and appeal this outcome. And I would like you to consider that. Thank you.
Thank you very much, Honorable Papane.
Thank you very much, Honorable Chairperson, for this opportunity. Let me join my colleagues in welcoming the presentation by the Parliamentary Legal Services. Honorable Chair, let me start by supporting the questions that were raised by Honorable Mahlaule, inputs by Honorable Ngola, Honorable Vessels, Direko, and Honorable Daniels. Honorable Chair, I just want clarity on as to how far is the committee expected to go in terms of its preparatory work. And also, what will be the role of the evidence leaders if they are procured during this time of the interim interdict? Then lastly, I want to join my colleague in saying that this interim interdict is until the hearing of the review by the courts of the president. So I just want to understand, will it not be, if evidence leaders are procured now, what will they be doing? Because evidence leaders are expected to assist the committee in identifying witnesses, prepare and receive these sworn affidavits or statements from witnesses. So if the committee, okay, I'll wait for the response so that I can have a follow-up on it. Thank you.
Thank you very much, Honorable Kwankwa.
Chairperson, thank you very much for the opportunity. Colleagues, this is, in our view, an exceptional case. First, the issues raised are, as some of our colleagues, in fact, most of our colleagues have already indicated, are of considerable constitutional importance. In this respect, they concern the respective powers and functions of Parliament on the one hand, and the President under the Constitution on the other, right? The second issue, I think it has been articulated eloquently by some of our colleagues, including Dr. Hlophe, among others, is the fact that the judgment itself demonstrates that these issues are contestable, right? The fact that the court was divided on the proper interpretation and application of the relevant constitutional principles means that the fact that the judges reached different conclusions is compelling evidence for us that that an appeal, as legal fundis would say, that there are prospects of success if we're to take this matter on appeal. And because of these differences of interpretation and application of the law, it means that we have to find some kind of certainty insofar as these matters are concerned. I agree with Honorable Ngola that this is an interim order, yes, but the difficult, or where we find difficulties, the UDM, is that although it's expressed to be interim, the order has immediate and significant constitutional consequences. Firstly, it restrains Parliament from exercising what we regard to be its constitutional powers, and also has the effect of delaying the performance of a constitutional process. In other words, there's the practical effect of the order, therefore extends beyond an ordinary relief. It has institutional implications that cannot be ignored, right? Unless we are okay with being reduced to being a Mickey Mouse administrative committee that can only deal with preparatory work and nothing else, and that we know, as Honorable Zungula mentioned earlier, that if that precedent is set and you don't challenge it to try and find finality on this matter and the powers of parliament, the attempt to impeach President Ramaphosa is probably not going to be the last one. There are what do you call them? Like your public protectors and whatnot, Chapter 9 institutions, the heads of Chapter 9 institutions and others that go through similar processes, for example, in Parliament. If we create a template that can just simply curtail the powers of Parliament or render it completely irrelevant in a process that is supposed to be done in Parliament, then we are running that precedent poses a serious risk to the functionality and the powers of Parliament as an institution. So, in those words, we do indeed support 110% the proposal to appeal the judgment. I thank you, Chair.
Thank you very much, Honorable Dagmo.
Thanks so much, Chair. Chair, also thank you very much to Parliament's legal advisors for the report. I note as well in their report that they in no way proposed an appeal. And I think it would be important at the end of this discussion, in the light of the various positions that members have raised, for the parliamentary legal team, which doesn't cost us anything, to actually reflect on what are the implications of this committee supporting an appeal. I support the questions of clarity that were asked by Honourable Mhlauli, but I would like to refer the committee to the Constitutional Court judgment, which all of us are obliged to honour and to ensure that the impeachment process is properly managed. If you look at clause 139 of the judgment, it says very clearly that where the panel concludes that sufficient evidence exists to disclose a prima facie case, its recommendations that a Section 89 inquiry be proceeded with must be implemented through a referral to an impeachment committee. And this is the important part, unless and until the report is set aside on review. Now, in terms of fairness, the President has raised issues with the panel's report, and we should recall that he initially wrote to the committee asking that there is a recognition of the fact that this matter will be heard on review, and sought a commitment from this committee to allow that process to continue. This committee then, despite the fact that some of us argued that we should abide, decided to oppose that particular interdict, and we now have a judgment. The judgment talks specifically about a pause in the process, and there's a specific wording in the judgment of the Cape High Court that, given that the review application will be heard between the 3rd and 4th of September, there's a reference of the Judge President which says that there will be definitely consideration around the urgency of the matter in terms of coming to a finding in regard to the review application. Obviously, if a review application happens, if the President succeeds, other parties might decide to take that particular review, that particular judgment on review. And the President will obviously exercise his rights in this matter. So here we have a constitutional court which clearly establishes the right of the panel's report to be taken on review. And it seems there's an unwillingness of members on this, or some members of this committee, to accept that that is the right that the President is exercising. It doesn't. This committee has honored the judgment of the court. We've continued with the work that we can do. It's a pause. It's not a stopping of the work of this committee. And it seems that some members, should not drag this committee into their own legal battles. Sometimes a court makes a decision and the court is captured. Another time the court makes a decision and then the court is not captured. And what we're having here is a fundamental unwillingness to accept the right, in this case, of the President to take the panel report on review. A right, in fact, which the Constitutional Court judgment in paragraph 139 actually says very clearly, unless and until the report is set aside. So why are we, as a committee, wanting to get into the mud with other political parties around taking this particular this judgment on review? And I think that I want to propose, I support those who've argued that we should not involve ourselves, that we should simply abide. And given that the parliamentary legal team did not advise on that issue, I would appeal, Chair, that given the debate that we're having here on the issue of whether to support an appeal or not, that the parliamentary legal team comes back to this committee with the implications. There were many here who criticized the Speaker for abiding. The Speaker was actually proved to be correct in her position to abide. Let us not, as a committee, fight political battles for other parties. Let the process continue, let the review application be heard, and we will then have clarity at that point in time. Thank you very much.
Thank you, Honorable Mtambi. I will not give a second bite, Honorable Swart. Honorable Mtambi.
Thank you, Chair. You'll pardon my bandwidth is not that good, hence there's no video. The Chair, thank you so much, Chair. What we are also saying, Chair, it's our respect for the court, not the triumph, because we have welcomed the interim order because it protects a fair sequence, not just because to delay things as some people are saying here. The issue here, Chair, the majority of the full bench granted the interim interdict on 24 July, and then it stays the public hearings until the review is heard. And the date is already set, is 2 to 4 September. We're almost now in August. This is the last week of July. Whatever applications that we're going to make for now, definitely they're not going to be heard before that date of the first week of September, as the court has said. And then in line with our issues, we have accepted the legal opinion, even the verbal one earlier. So I should think we must give the legal team to also look on these other issues that their opinion is silent on. Secondly, also, we have raised questions in the line with Honorable Matlaola. If those questions can be answered, I think that will give us a way forward to be able to have a clear determination and way forward on this matter. Because now, where we are seated now, Chair, we must also recall that whatever we do, the other party also is entitled in terms of Section 18 of the Superior Courts Act to also make the similar application. And then it will be continuous litigation. And then what about the value for money aspect? Because the 2nd of September is just around the corner. So do we incur all these expenditures rather than waiting for the review application to be heard on the 2nd and 4th of September? Indeed, the court is very clear to say that we need we are interdicted until this made pending the determination by the court of the application of the applicant's review. So I see no harm that will be suffered on our part for us to then allow this process of the review to take place. And then at the same time, we rather, just to save the resources of the committee, we rather wait my apologies, we have rather wait for the court to make a determination and take it from there. And also that we can then allow the expertise of our legal services to also give us an opinion with regard to the implications of us then appealing this decision. Thank you, Chair.
Thank you very much, Honorable Ngobeni.
Thank you very much, Chairperson. I hope I'm audible. I am also experiencing very grave connectivity issues. Chair, I'm finding the conversation, though, we must debate these matters, but I think we are really amiss in terms of the principle through which we are debating these matters. Firstly, just to pick up on what the previous speaker was saying, to wait, etc. Firstly, that this committee should not be at the behest of anyone. We are not lame ducks that must wait for other processes before we must discharge our own duties. The first principle is that Parliament oversees the executive. It's not the other way around. We can't be held hostage by the president himself, who we must oversee. And in as much as the president himself has got the constitutional rights to approach the courts in order to vindicate his own rights. And of course, nobody disputes that. And I think that's been a unanimous understanding in this committee. But equally, we believe Parliament also has the right and the duty to defend our own constitutional mandate, where we believe that mandate has been duly constrained. And I think those of us on that side of the argument want to assert that view. We should not even be at the point where we are discussing political party interests here. We are Parliament, we are representing the people of South Africa. The only largest and most critical stakeholder we should be defending here are the people of South Africa who want to know what happened at Phala. So it's important for us to do that. And also, this matter that we are debating here, Chair, is not simply about one president or another committee, which is our committee. But this is a constitutional question, and we are also a key stakeholder in the framing of what happens within our country, and we should be able to make sure that there is no judicial overlap and the boundary between judicial oversight and our parliamentary work as those who are overseeing the executive in this regard. The work that we are doing of Section 89, Chair, it's one of the most important mechanisms for accountability. And we want to assert and align ourselves as Action SA with those who say this committee should consider challenging the court order of last Friday. Because if the president, and I assert once more, if the president can be defended to be able to protect himself from any level of scrutiny, we should also be doing exactly the same thing. And as a committee, honestly, in this regard, we should be in one accord. I don't think that the president needs anyone to speak for him at this committee. He does have his own legal team that has fought for him, even in the courts, and that should be their job. Our job should not be to whether he's got enough leave to do what he wants to do or otherwise. Our assertion here is to say this committee should absolutely consider challenging this court decision. And lastly, on that score, Chair, to challenge a court decision does not mean that we do not respect the courts and the judicial process. We do not disrespect it. But also we must remember that judges are equally human beings. They do err, they have erred, judgments have been appealed. That's why you've got a mechanism to challenge or to appeal what a decision of a court may have done, which is exactly what the president has done. And as this committee, honestly, I want to implore each and every one of us to honestly be on the side of Parliament and on the side of the people and not on the side of anybody else who's outside of that forum. The executive must do what it needs to do to fight for itself, but we must do what we need to do to fight for ourselves as well. And we don't believe that is disrespecting the orders of the court. And I really just want to make that particular assertion, Chair, as opposed to party political fightings or party political misunderstandings or perceptions that are being created about whether people are trying to delay processes, etc., etc. As a principle, I would implore us as this committee to really be in one accord with regards to what our work is and not to interpret on behalf of the president and the executive what our work should be. I want to leave it there for now. Thank you, Chair.
Thank you very much, Honorable Maneli.
Thank you, Honorable Chair, once again. Thanks, Chair. I want to start from the point that reading what has been presented, which one welcomes from the legal team of Parliament, which is meant to support the work of this committee. they did, as you move towards the end, given a sense of what the implications are, but also makes the conclusion on what the committee could focus on at this point in the way of looking at the judgment, which I think for me, as a member of this committee chair, I agree with that, so that when you look at further clarities on to what extent can you go forward in looking at that preparatory work, they should also be guiding us that in the course of doing that, we are not perceived or even seen to be actually in contempt of the same interdict that has been given. I think I accept that point from that angle. Otherwise, from where one is sitting, Chair, we should also not debate as though there is no court order that has been given, even if you would want to look at it the other way. Once there's that majority taken, it then places it as an order. And I think for me, I also applaud you, being the chair, that even with the court order coming out, you still convened us to continue with the work that we can be able to do as a committee. And I would want us to really take it in that way, Chair. And I'm putting this as to justify the reason, really not to get the committee to be pulled through to an appeal when almost everyone would have talked to that, except, of course, for us who are advancing this position, that the chances may not really be there at this point where you can really prove that the court has halted completely the work of the committee. So the court has said you can continue with your preparatory work, which includes terms of reference, as I said, in terms of this conclusion. We have adopted an agenda, Chair, with amendments. And in that amendment, you have also indicated that there will be consideration of terms of reference as part of looking at our internal arrangements for the committee to start working. I'm not sure that we are not even at a position even today to adopt, because there are those matters that we said are hanging, hence we changed it to consideration. So we're still working on the arrangements internally on how the committee needs to proceed, which are not prohibited by this interdict. I will therefore not see, Chair, a reason, instead of doing what we are able to control and do, but we run and ask for a court elsewhere to interpret whether we can still be able to do what the court has already clarified in that score. So I would want to really lobby, Chair, not to get the committee to that extent, whilst we respect the rights of others to have taken the matter already in any way. Thank you, Chair.
Thank you very much, Honorable Khadebe.
Thank you very much, Honorable Chairperson. Greetings to you and to the honorable members. Chairperson, I would want to say that when we consider the pace at which the committee has been operating, that the preparatory work would likely still have been underway, even in the absence of the interdict. Consider the fact that members are still able to review documentation, the committee. We are still able to prepare for the inquiry, undertake the necessary administrative work. I think the only restriction is that witnesses cannot be called pending the outcome of the review, Chairperson. I think in those circumstances, an appeal would serve little practical purpose and may ultimately prove to be a futile exercise. That is insofar as the IFP is concerned, Chairperson. And lastly, even if we appeal this interim judgment, the Constitutional Court, Chairperson, may only offer interpretation and their judgment limited to the scope of the interdict and not the entirety of the impeachment process. So in that regard, I would want to be tempted to support honorable members who feel that waiting for the period and the review, which is likely to be in a month's time, would do no harm to the processes and the work of this committee. Thank you, Chair.
Thank you very much, Honorable Khanyane.
Honorable Chairperson, good afternoon to you, and greetings to honorable members in the impeachment committee. Number one, Honorable Chair, I think there are pertinent questions that Honorable Mathaule has raised about whether the parliamentary legal team has made considerations about the applications of a particular rule in the rules of parliament, and I think it's 139M, if I'm not mistaken, which is very, very important, because if we got clarity on the interpretation of the judgment, particularly with regard to the application of that rule, what are the parameters that have been set? What is it that in terms of the court order we can do and we cannot do? I think by now we should have been very far with this meeting, because we would be knowing what is it that is permissible in terms of that judgment and what is not. And the fact that we are running around in circles is because we are lost. We have not got a sense if the parliament legal team was at the beginning was going to say to us, or would have said to us, in terms of the judgment, this is what the committee can do, and this is what the committee cannot do. I mean, the statement which has been made, which is very profound, I agree, was that they said we can go ahead with the preparatory work. But that is a condensed statement. It should have been unpacked to say, subject to this judgment on the application of 139M, this is what it means. And I can tell you, Chair, we would have made progress with this meeting. Number two, with regard to the matter of appeal, we might have learned lessons, and we might have decided not to learn when the first application for interdict was made. The High Court in the Western Cape announced it well ahead of time that the hearing was going to be on the 15th and the 16th of July. For sure, that announcement would have been made a month in advance. And now, if we, whether correctly or incorrectly, decide, because I should think that with every court judgment, we are learning lessons. whether we correctly or incorrectly decide to appeal this judgment, by now having learned from the past, we know, or we can imagine when would this matter be heard, especially when we go to the Constitutional Court. And Chair, I want to plead with ourselves that we must not do the work of this committee in such a way that in future we will have to go to court every day to decide what must be done. I can tell you, if we continue like this, we are going to be in court every day. And the manner in which we read and interpret the law, that cannot be done in ellipses. You don't read one part of the Constitution or one part of the law and you ignore the other. The law of this country is not written in the name of institutions. Institutions in this country have previously trampled on the rights of the citizens. And that is why the law of this country has been written the way it has been written. If we strongly feel that we have matters that must appear before the court, we don't have to be partisan. We don't have to be impulsive. We don't have to speak in our names. We don't have to speak in the names of the institution. Let us speak in the name of the law, because that is what is supreme in this country. And I think, Chair, this is what will guide us. If we are going to speak in our names, I can tell you, we will never, like the honorable member from Action SA says, we will never come to accord with ourselves or with what we have to do, because we are not speaking in the name of the law. We are speaking either for ourselves or in the names of our institutions. So the law of this country is very, very important and can never at any point be reduced to subjective interpretations. And I can tell you, Chair, honorable members have said it here, I'm not convinced that we should appeal the matter. But look, I'm a member of this committee and I'm always persuaded by the views of others. At whatever point we reach an agreement, if we feel that we must go ahead and appeal, let's do it. Thank you so much.
Thank you very much, Honorable Khanyani. I will go to the legal to respond on the questions that have been asked. But before I do that, so that the question that was asked on the day that we also resolved to go and oppose the application, there was a question that was asked to myself to say, all right, as a chairperson, what is your view? And I'll answer that question to indicate and not to reflect on what the members have said, because this is a view that I hold, and the view is taken in terms of both the conversations that one has had with the legal team, including the senior counsel that represented ourselves in court. And it's important that in the first instance, how we read the order of the Western Cape, it's correct in that the order is applicable up until the Western Cape High Court makes a determination on the application on the review application by President Ramaphosa. So this interdict on the impeachment hearings, the order lapses the moment that the Western Cape High Court makes its decision. That's what the first order of the Western Cape High Court actually says. And having listened to that judgment, gone through the judgment, I had a conversation with the senior counsel together with the legal team to go through the judgment, also considering the option of appeal. And it was during that conversation that during the questioning and also going through the judgment, that I was not convinced that we should go on appeal. One, just the timing, the time available to send the matter to the Constitutional Court, because first, and what I had asked was whether on this particular matter, an appeal is automatic. Or you still have to ask the Constitutional Court to then grant the leave to appeal as the first instance. And once that leave is granted, you have to go and make your arguments to say, why do you believe the Western Cape High Court, the majority decision, it's incorrect. And then the third part was on the ruling. And what my interest was whether there's a likelihood that the judgment of the Constitutional Court, having gone through all these steps, whether there is a likelihood that the Constitutional Court could deliver its judgment before the 4th of September. That's when the review application is set down. And what I got was that it's unlikely that the Constitutional Court will have delivered its judgment on the matter before the review application is actually had and decided upon. And it was indicated to myself that you could have a situation where in the review application judgment could very well come before the Constitutional Court judgment. And after having those conversations, I felt that it's not, at least from my side, it's not something that I believe we should go through as a committee, go on appeal. Obviously, there are parties. I think I use parties not in the sense of political parties, but parties to the matter that have indicated, that have asked the Constitutional Court to grant leave to appeal the judgment. And those, I think all the respondents or the parties are within their rights to do so. But the work that we still have to do as the legal service has given to say that we need to continue with the preparatory work that this particular interim judgment does not stop us from doing our work. And it is for that reason that this meeting was convened, and it was convened, and that it's proceeding, and the work will continue to proceed. And finally, one of the things that I said, even on the day that we deliberated on the opposition to the interdict, was that my posture on this matter, or on how the committee needs to proceed, is that we will proceed until such time that the competent court has delivered a ruling. And so even my response to the letter, you might remember on the 24th of June, when we considered correspondence, I shared the correspondence that I had given to the president when the president had asked myself to say that, can I please stay the public hearings, the hearing of evidence? I said, I can't do so myself. If you want that to be done, you need to approach the courts. Let it be the courts that then directs ourselves as the committee that there are aspects of our work that we cannot proceed with. And once that ruling has been delivered, I will respect that ruling and continue with the work that we are allowed to do. And having considered everything, I am of the view that we at least, this is me as a chairperson, because this question was asked last time to say, what is my view? My view is that we should not go on appeal, but that if the Constitutional Court does make a determination of whatever nature, we will then proceed. I will now allow legal to now respond to the questions that have been asked. And once legal has responded to that question, we'll come back for a follow-up. Thanks very much. And can you please respond to the questions that were asked by honorable members of a legal nature? Thanks very much.
Thank you, Chairperson. I'm just going to share my screen again so I can refer to the judgment. Thank you, Chairperson. I think a lot of the questions asked us to clarify our interpretation of the court order. And I think I want to premise my comments by saying we are interpreting and not clarifying. This is an order of court and as handed down by the Western Cape High Court. So we would use ordinary legal interpretation to determine what the meaning of the words of the order are. So the order that is of relevance is order 1, which says pending the determination of the court of the applicant's review case under case number 2026-119192. The first and second respondents are interdicted from proceeding with, and the important words are public impeachment hearings in terms of Rule 129M of the National Assembly Rule. Now, in this regard, I think what is important is the words public impeachment hearings in terms of Rule 129(1). So how do we interpret that? We would give the ordinary meaning to public, which means something that happens in front of people that is visible to others. And impeachment hearings, we would take that to mean hearings regarding the impeachment of the president. Let us reference Rule 129M, and which the court says we must not have public impeachment hearings with regard to Rule 129(1)M. That relates to functions and powers of the committee, and it says in 1, the impeachment committee must proceed to establish the veracity and, where required, seriousness of the charges and report to the assembly thereon. The second number says the impeachment committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time frame. 3 says the impeachment committee must afford the president the right to be heard in his or her own defense and to be assisted by a legal practitioner or other expert of his or her choice. And 4, for the purpose of performing its functions, the impeachment committee has all the powers applicable to parliamentary committees as provided for in the Constitution, applicable law, and rules of the National Assembly. So therefore, in interpreting this, it's our view that the committee is only interdicted from the public impeachment hearings, and that would mean conversely, anything that does not relate to public impeachment hearings will be allowed. So our interpretation is that this includes all preparatory work apart from public impeachment hearings. And in our view, ordinarily, what work would the committee be required to do in preparation for the impeachment hearings? It would be to appoint evidence leaders, to allow the evidence leaders the scope to go and prepare, read the record, all the documents, indicate which evidence is relevant, get witness statements. There will also be background preparations in terms of committee section, so that is the preparation that we envision that will be required. With regard to the scope of the evidence leaders' work, as indicated, I'm of the view that the committee is still under an obligation to proceed with the preparatory work, even though the review is pending. the report is still before the committee, and the committee is only interdicted to a certain extent. So the committee has to fulfill its obligation, its constitutional obligation, without undue delay to proceed with what work it is allowed to do. So in that regard, it is our view on interpreting the court order that the committee may do all this work, including appointing evidence leaders. With regard to as to whether this is going to cause unnecessary expenditure or fruitless expenditure, this is a decision that the committee has to make. It has to prepare, and this will incur cost. In the event that the review is successful, then yes, the money would have been, the cost incurred in the work of the evidence leaders will have been not necessarily in vain, but it wouldn't amount to anything. However, the conversely so is that if the review is unsuccessful and we are required to proceed, say in September, October, then we would then require the evidence leaders to start at that time, which would have meant we would have wasted about 2 months. So it is something that we have to consider. And in light of our constitutional obligation to proceed is that either way, there is there is a cost involved, whether it is time or money. And in this regard, I think it will be important for the committee to fulfill its constitutional obligation and allow the evidence leaders to prepare in case that the matter has to proceed in October. Chairperson, I think those were the issues that I was asked to comment on regarding the appeal and the implication. I think the committee has discussed this matter extensively as to the way forward. So I will, and you've already made your comments. I will stop there. Thanks, Chair.
Thanks very much, I'm just trying to check whether I think you did respond on the fruitless or fruitless expenditure, and then on the role of evidence leaders, did you reflect on that once they were to be appointed, or was that part of the fruitless expenditure explanation or expenditure or cost?
Chairperson, I can comment on that. I think the role of evidence leaders is to lead evidence in the committee, but they need to prepare to do that. And that requires a lot of background preparation. The report itself is quite extensive, so they would require time to read the record, analyze the evidence independently of what the report has said, do their own independent research. So although we call them evidence leaders, their role, there's a lot of work that they do to be, before they can present that evidence to the committee. So that's what, if they are appointed, that's what will be the scope of the work, is that to prepare for the inquiry that is anticipated to take place.
Thanks very much. I see further hands. I see 4 hands. Honorable Mautwe, Swart, Honorable Songola, and Mahlauli. Honorable Mautwe.
Thank you, Chair. Chair, I've been trying to get assistance from the support staff to let in the president of the EFF into the meeting. He's struggling. He's been trying to join with his iPad and he's not successful. He tried with his phone, but his battery is low on the phone. So if you could please ask the support staff. Number 2, Chair, can we subject the issue of the committee appealing the matter to a vote? Because you've heard your view. We had our views as members of this committee, and we feel that your view can't be an overruling view. I'm sure you've seen with our inputs that majority of us in this committee are requesting that we should appeal the matter. When we agreed to oppose, we knew what comes with it. So you can't build a foundation of a house and claim that it's a house. It's not yet complete. We need to follow the process until it's completed. And therefore, it is for this reason that, and the reason that we have already advanced previously, of what the grounds of appeal, why we strongly feel that we should take a resolution as the committee, like we did when we took a resolution as the committee to oppose the matter. We take it now that we appeal this matter. Not maybe not necessarily for us now, but even for future reference, because this is the first of its kind, and it will set a wrong precedent, Chair, that we can be interdicted at any point and stop and go. We're not into construction programs. We are dealing with an impeachment process, and therefore it's important for us. So our request to you is that let's subject it to a vote. I thank you.
Thank you very much, Honorable Swart.
Chair, yes, I want to agree that we should submit the issue to the vote. We argued very strenuously at the beginning, and without going into it again, as you indicated, a second bite. But I do want to refer to what Senior Counsel said when he motivated for us to oppose the interdict. He said, an interdict against the committee would constitute direct interference with the committee's constitutional mandate. Passivity or neutrality would be inconsistent with the IC's duty to defend its mandate. We submit that situation has not changed, Chair, and that we should submit this to a vote now. We can't wait for a legal opinion because you've got 15 days from the date of the judgment. Time is of the essence to prepare papers for the application for leave to appeal. It's a beginning stage, Chair. It's not, you first have to apply for leave to appeal. And I would strongly urge that we have a vote on that. And I appreciate that, but bear in mind, Chairperson, you are the Chairperson. Last time we gave you a mandate to oppose. It's now for the committee, whether by majority or otherwise, to give you a mandate to apply for leave to appeal. Thank you, Chair.
Thank you very much. Zungula, is it a different point or it's supporting the vote?
Supporting the vote. Also, maybe to make a correction, Chair, that the council advising you would not have said that this will be concluded in September, because the hearing is in September, but the outcome of the hearing, there is not definite time as to when that will be. So your assertion that this, by the time the Concord would have even said adjudicated on the matter would have been concluded, it is incorrect, because there is nothing that suggests that the Concord cannot meet, hear the issue, make a deliberation before the Western High Court issues its judgment on the issue. So if your reasoning to be against the appeal is premised on a misguided view that the Western Cape High Court in any case is going to conclude on the matter and give a determination on the matter before the Concord, I think that is incorrect. Let's go to a vote. Let's move. And the last thing I want to raise is that the meeting started at 10 o'clock. We are now at something to 2, perhaps because we seem to be spending so much time over what's important for members to express themselves. But we must be cautious, Chair, of having long-winded meetings that might affect some members from participating. For example, now there's going to be a discussion on the evidence leaders. And then once that decision is, we need to decide. Members, when they get an agenda, they plan that they're between 10 and 1 o'clock, they are going to be in a meeting. So if you can just look at not having meetings or statements that end up delaying, not for the purpose of enriching the discussions of the committee, but perhaps to frustrate the pace in which the committee lives, to an extent that when decisions are taken, we do not have the full complement of the committee. Thank you.
Thank you, Honorable Zungula. Just to say that it is the members who are speaking in the meeting. So if there's to be any aspect around prolonging the meeting, it's the members themselves who are speaking. There's no one else outside of the members that are speaking in this meeting. Honorable Mashaul.
Thank you very much, Chairperson. Chair, I don't understand at what point do we agree with a legal opinion, either from Parliament or from SC. You make a point that you spent some time with the SC and the legal team. You looked at every angle, and the conclusion was that you shouldn't appeal. Some members here were not happy with the speaker when she was given a legal opinion and she sourced another one. They said it's wrong. They even wanted her to be impeached. At what point do we get to accept a legal opinion if indeed, Honorable Soviet, we are not doing it for ourselves, but for the citizens of the country? The legal team here clarifying or attempting to clarify what I was asking, they made it a point to say that their job is not to clarify, Honorable Chairperson, is to interpret what the court said. And therefore, it makes it very difficult to proceed without clarifying certain issues that I have raised, including what is a public hearing. And if you say, you look at our roles and duties, part of it is to establish veracity of the facts. How do you do that? You have to speak to the people. Do you speak to people in Parliament, or you speak to people out there who are affected? What do we call that? And if you go out there and get witness statements, where do you get the witness statements? Are you not getting it from people who are affected? And are they not public or citizens of the country? If these things are not clarified, we will have a problem of selectively proceeding with what we think we want to achieve over what we think we don't want to achieve. Still, Rule 129's interdict needs to be clarified holistically, not in bits and pieces, Honorable Chairperson. We won't comment much on the vote or no vote. We just appreciate that you sourced legal opinion and it said we must not appeal. Thank you very much.
Thanks very much, and I'll clarify that matter. Honorable Gama.
Thank you, Chair. I rise just on two issues. The first one is the issue of time. I think we should maybe just agree that at 2 o'clock we will have gone over the allocated time by an hour, and that maybe at that point it would be an appropriate time to stop the meeting and defer it to another date. The second issue is we must not abandon the mandate of this committee, that we should defend it, and that I agree with those who say, let us put this matter to a vote so that we can settle it in terms of whether or not to appeal the judgment and decision of the Cape High Court. Thank you, Chair.
Thank you very much. Honorable Daniels.
Thank you so much, Chairperson. Chairperson, I've noted, my apologies, I've noted through the different platforms or media where the news makes mention of certain parties already decided and made public statements that they are going to oppose this. So I've got a question to you, and it's a clarity-seeking question only, Chairperson. Should you decide to oppose this, will you do so in your personal capacity? Or is it on behalf of all parties represented in this? Before I continue, Chairperson, I would just like the clarity-seeking question to be answered.
You want to continue, Honorable Daniels, or you want me to respond before you continue?
Please respond, Chairperson. I appreciate
as a chairperson of the committee. I'm cited as the chairperson of the committee.
Yes, but I'm not a legal fundi chairperson, so I'm hoping that you can guide me for my clarity. Is that as a chairperson, it is still in your personal capacity, or is it on behalf of the committee as the chairperson?
Without the committee, I will not be the chairperson. So it's on behalf of the committee. Thanks.
No, it's fine. Thank you, chairperson. No further question. No further clarity seeking questions, Chair. Thank you.
All right. Thanks very much, honorable members. Just one clarity, just so that we don't, and then tomorrow someone writes to me and say, Chairperson, can we see a copy of the legal opinion that you received, so that we can check whether it was received before or after the meeting, indicating that after the judgment on Friday, we had a near 2-hour meeting with the senior counsel and the legal team that was representing us in court, where we went through the judgment, the implications, the options that were available, and the questions that were asked to the legal team. And it was after that conversation and the responses that were given in that meeting that I felt that it's not, at least from my side, that the matter should not be appealed. So there was no like a written a legal opinion on whether we should appeal or not appeal. It's a decision that was taken in the course of a conversation that we had with the entirety of the legal team, both from Parliament and also the team that has represented us. But I think we have exhausted this matter, and we do need to make a decision. And as it's the case, when we can't find each other, we then go to a vote that we have to take as proposed, so that we settle this matter. Because it's very clear to me that there are opposing views on this matter, and we can talk until tomorrow. We will struggle to find one another. So we need to settle this matter. Honorable Dagmo, is that order or?
Yes, Chair. Just a clarity point. Given that a number of people have made arguments around the timing, and this would be frivolous, etc., is it for those members that vote in favor of appealing, and if in the event of a costs order, will that costs order be specifically applicable to those members who vote to go on appeal?
Chair, please protect us. It's been a long day.
No, Honorable Maudwe. Can you please not do that? Please. So, Honorable Dagmo, the person that's cited is the chairperson of the impeachment committee. So if there's a cost order, it will come to the chairperson of the impeachment committee. And as I've said previously, that we are supported by by Parliament. So when we are here as a committee, we are a committee of Parliament. The decisions that we take them as a committee of Parliament. So if there's a cost order, it will not be passed down to individual members. So I think that one, it's let's not go down there where now individual members in the committee will bear the cost. It will be the cost of Parliament, because we are a committee of Parliament. So I would like to proceed to the vote. I see the hand of Honorable Malema, or I think it has gone down. I want to proceed to a vote, and ask those who say that on behalf of the committee, we should file a leave of appeal to the Constitutional Court, because currently there's no appeal that has been granted for us to appeal. So as the first question, and then Are these hands asking to speak or the hands are voting? I've been asked
We're
for
voting, Chair. We're voting.
I've been asked you to vote. You don't have a ballot paper, so what are you voting on? I haven't given you the ballot paper yet. Honorable Kwankwa, is that the hand of voting or is that the hand that you want to speak?
No, Chair, you called for hands for voting. I'm voting.
I've been called for hands.
So what I need that must just vote.
Please take it down. Thank you. Those who say that the committee must join the appealing the Western Cape High Court decision, now you can raise your hands.
Mr. Chairperson Uchope, yes, I raise my hand. I vote in favor. Thank you, Comrade Chair.
It will be noted as such.
Thank you.
Tembinkosi, are you noting the hands, counting the numbers?
Yes, indeed, Chairperson, I am noting hands and counting the numbers.
You let me know once you are done counting the numbers.
Chairperson, thank you. Yes, we are done.
All right, thanks very much. If I can ask all who have voted to take down their hands. Thank you. Those who say that it should not be appealed, please raise your hands.
You must don't forget to vote, Chairperson.
And because you let me know once you are done taking the hands.
I am done, Chairperson. Thank you.
All right, thanks very much. You can do your tally and present the numbers.
All for those who are abstaining, Chair.
Oh, sorry. I saw like everyone voted. Please take down your hands. I think let's take down our hands.
Chairperson? Hello?
I see two hands.
Can I just
Two hands.
I'm not sure if it was noted. Thank you.
There?
I'm saying I'm not sure if my hand is noted. I hope it's noted in support. Thank you.
All right.
Chairperson,
Honorable
Swart,
Swart,
yeah.
I want
Chair,
to
I'm
go
not.
to those who are abstaining, unless if your hand is abstaining.
No, it is about a point of order as to whether you as a chair are able to vote. You might have to have given over the chair, but maybe for clarity in this case, I do appreciate that you are cited as a respondent. So it's quite a unique situation. I'm not objecting, I'm just raising going forward whether you as a chair have got the right. Normally a chairperson would cast a deliberative vote should there be a tie. Thank you, Chair.
I will go to those who are abstaining, and then I'll respond to you, Honorable Swart. Can you please take down your hand, Honorable Ngobe? Because if you could just lower the hand of Honorable Ngobe, thanks very much. Is there any member in the committee that wishes to abstain? Oh, there's no member that's abstaining. Honorable Swart, before we get into the result, so the chairperson, in terms of Rule 158, in terms of 1582D, so it reads as follows. It says the chairperson of a committee, subject to other provisions of these rules and directions of the committee, in the event of an equality of votes on any question before the committee, must exercise a casting vote in addition to the chairperson's vote as a member. So 1582D will indicate that as a member of the committee, the chairperson vote. If there's an equality of votes, the chairperson does the casting vote. So it's in line with the rules of the National Assembly. Thanks. Temkosi, please present the result to me, to the committee, not to me, to the committee, before someone says something else.
Then, good afternoon. Chairperson, the results for appeal 14 and against 13. There was no abstentions. Thank you very much. Chair.
So the vote for appeal is 14.
Chair, sorry, Chair. I counted 15 with Honorable Ngobeni, Lerato Ngobeni. 15.
All right.
Chair, with respect, we have an electoral officer here. That is the committee secretary.
No, but when are your priority things you are going to manipulate us? Just chill,
no.
relax.
Honorable Malema.
Your superiority must never think you are better than us.
Honorable Malema, please. Please. The votes have been announced, and we'll just double check, but the addition of Honorable Ngobeni does not change the decision that the view of the committee is that the Western Cape High Court judgment should be appealed. So even as we add, that's the decision of the committee, and all members have participated in the vote. Those that says must appeal is 14, as announced. And even if we add the other members, it will not change the outcome. So it's a split decision, but it is a decision nonetheless. So we will then proceed with that appeal on behalf of the committee. So this matter will then rest on this particular point. Just to say, honorable members, that we had allocated the committee to meet until 1 o'clock. It's near 2 o'clock now. And we haven't dealt with the two matters of the evidence leader and the terms of reference. This necessitates that next week we will not have just one meeting. We'll need to meet for 2 days. And I've asked the committee secretary to then make an application for us to meet on Wednesday and Friday next week, so that we can conclude the business of the committee. The evidence leaders and the terms of reference will stand over to next week. We'll then continue with the meeting next week, try to finalize or get close to finalizing on those two matters. So I want to adjourn the meeting. At this point. There were two major decisions that were taken today. One was that the authors of the independent panel report will not present the report to the committee, that the report is now with the committee, so they don't have to appear before the committee to present their report. That was a decision that we took earlier. And now we've just taken a decision that the committee will then appeal the decision of the Western Cape High Court, legal, and everyone else will start working on that decision to ensure that the papers are then submitted to the Constitutional Court. Honorable members, the meeting will, as I said, the meeting will be adjourned now. It will continue next week, Wednesday. Given the number of members in the committee and also not wanting to stop any member from participating in the deliberations of the committee, we need to look at starting the meeting at 9 o'clock next week, Wednesday, so that at least we have adequate time to deliberate on these matters. As others will have said, that this is a weighty matter that we are dealing with, and we need to afford each member adequate time to present their case before the committee, state their views without suppressing or even trying to limit in terms of their participation in the committee. So we will meet, like I say, we will meet on Wednesday. It will be 9 o'clock next week, and then also on Friday next week, 9 o'clock. And maybe we need to push it from 9 o'clock to 2 p.m. On Wednesday, and 9 o'clock to at least 2 p.m. on Friday. But what I would like to appeal to honorable members, if you could just look at the list of evidence leaders or the advocates that have indicated availability to be evidence leaders, and try to talk to one another and see if we can find consensus on the evidence leader. That's the first one. And then secondly, it's on the terms of reference. If you could just spend some time on the terms of reference, try to find one another so that we can move as close as possible to finalize those items next week. But also, I'm confident that we'll have that legal opinion on the questions that were asked in the last meeting. Honorable members, this brings us to the conclusion of today's meeting. Thank you very much, Councillor Snell. Siyabulela. Bayadanki.
Cancer Magweru.
Councillor Snell.
Thank you, Chair.